where crimes are baked in every show, mysteries rise and truth unfolding. Ready, set, it's time to go. We say it's time to go. Whistling clues, battering news, mixing stories, solving the lies. In this kitchen, secrets are broken with a spark in our eyes. In the broken baker's kitchen, the secrets crumble like sunrise. We'll sift the blues to find the news with a spark in our eyes. The broken rise, broken rise. Welcome to the broken baker. Get ready. Let's go.
I'm Jimmy. How y'all doing?
The most important people in this case that everybody seems to have forgotten in this room is the jury. So we're going to take a 15-minute break and both sides take a pregnant pause and think about the jury.
Good morning, good evening, good afternoon, wherever you are, whoever you are, what if any you might be. And something who is something is Mo. Someone?
I am both someone and something. You see me. I feel seen. Thank you.
I can't find my picture of Drunky the Bear.
I made a Lego Drunky the Bear. Because when I put Lego hair, it just assumed I wanted a Lego bear.
She's dyslexic. We'll fix it for her. But where the F? I found it earlier. Now I can't find it again. What disc is it on? That's the big problem, having all of these discs. You're sitting here thinking, did I put it here?
Yeah, it's hard because I have to periodically clean out my memory, and I need to start just creating file folders, but that would be...
Yeah, that would be professional. We don't do that.
Yeah. No, still waiting for my assistant to come do that. I like it.
The hair was a little too curly, but I couldn't get it to straighten it. But it's got a Dr. Pepper.
Yeah, and she's not wearing a bra. I mean, it is true to life.
Could I fit a bush in there? Well.
That's tomorrow's idea.
Maybe sometimes I should not say stuff.
Welcome to my world where I'm like, that should have been an inside thought and not an outside talk.
And Sammy spills the tea. Happy hump day. Morning, Baker. Morning, chat. Morning, Jamie. Jamie hasn't showed up for work as always. Jamie is... this week, she is saving the whales. She is out in Alaska, swimming with the beluga whales. It's an endangered species. Jamie is singing them Michael Bublé songs in a hope that they will be more fertile. So if you hear...
Makes sense.
In Alaska, it's Jamie doing I Will Always Love You in a whale voice. I don't know if Sammy Bublé or whatever his name is never ever made I Will Always Love You, but Jamie has her rendition of him.
Well,
I'm never going to see Jamie because she's going to beat me with a hammer when I meet her.
You will see her. You just won't be able to see afterwards, or there'll be two of her.
Why do you keep claiming I do? I don't know. I don't know, Jamie. Why? Why? What's the problem, Jamie?
And Amy, this is not the trial today. This is we are finished. They are finishing up jury selection, but there are also outstanding motions in limine, basically pretrial motions that the judge has to hear and rule on.
Today, at least what they have found, Jemima and Marissa, it's amended response to state's motion in limine to exclude battered spouse syndrome evidence or mention of battered spouse syndrome evidence until defendant testifies. Comments to state's motion in limine to exclude battered spouse syndrome evidence or mentions of battered spouse syndrome evidence until defendant testifies, and defendant's Fifth Amendment reciprocal discovery exhibit list. So that's what's on the docket, at least for this morning.
Yes.
Thank you, Sammy, for remembering Mo. For the afternoon, it's supposed to be Wadia, and tomorrow morning is supposed to be defense Wadia. And I'm thinking, how many experts can the defense bring that we can fill an entire morning with the Wadias? Because they're going to bring that chick, Helena, Dr. Helena, Dr. Helen, whatever her name is, and the other guy.
Yeah,
hey, Bendy,
I guess I do wonder about the crime scene reconstructionist. We saw the video. Do we need, Cannon Daddy to come back? Like,
yeah, 50 witnesses. It's overkill us a little bit. I can't wait to see Sarah's hair and makeup. Well, her hair will be exactly the same as every time. Style.
I am waiting. Oh, Jedi Jess is correcting us because we don't know what we're talking about.
Well, I have all my knowledge from her and Marissa, and they said it's Wadia of the experts. Maybe they said that. Maybe I read it while I was half sleeping, and I just made it up. That's what I said, Jamie. Come on now. Jamie never listens to me.
Yeah.
The state objects to the defendant's use of state exhibits in that many exhibits the state can introduce, but the defendant cannot. For example, the state may introduce hearsay statements of its party opponent, the defendant, whereas she would need another hearsay exception to introduce her own statements. Item 1, the defendant has not disclosed this item to the state. It's going to be interesting because I just got the 10 pages of her Fifth Amendment motion, and talking about someone who always plead the fifth. Hey, Jamie, did you save the whales?
I did. I just got back
from Alaska.
I just got back into town.
And thank you for becoming a member, Iron Rabbit. I appreciate it so much. I hope you're having fun in your barn now. And John Gary, welcome. Sorry, I'm suffering from the first time of ever being woman cold. I mean, I used to think that maybe I was an alien because I never got, girl cold. Like, you see all those women like just curled up. And now my body is like, no, we don't know temperatures.
Yeah. You hit 40 plus, everything will be hot, cold, cold, hot, hot, cold, cold, hot. And sometimes at the same time.
Yes.
And thank you, Shishi, for the raid. Welcome, raiders. Yes, Jamie did really go to Alaska. I tell no lie. I am the Danish Abraham Lincoln.
Yeah.
I'll start a civil war anytime.
Oh my gosh.
Like I put in my about pay or whatever that one is called. I said we will make the funniest. I'm not saying we'll make the best coverage, but we'll probably have the most fun of everyone covering this.
Of course.
Did she really save the beluga whales? Well, we have to wait. I don't know the pregnancy period of a beluga whale. I know mine is slightly longer than 9 months. So,
okay.
Hey, Wiki. Caitlin is ready for Sarah Boone Day.
Aren't we
Yeah,
all?
I-
Well, it's
I
not
feel like
really
this is
Sarah
like
Boone Day.
green.
But you know, this has been just, it's a long time coming. We have waited so long, it feels like.
Jamie, I thought Baker said he was swimming with the whales, and that was his family. I should have listened better. Sorry. Am I attacking Jutland or Sjælland? I am attacking Sweden because it's occupied Danish territory. I will free it. Free at last. Free at last. Skåne, Halland, and Blekinge will be free at last.
Okay.
Well, there you go.
So Nick will be a Dane after my war.
There'll have to be, you know, some hand holding and some hugs, but I think you guys can achieve peace afterwards.
Actually, we've been in the longest no war period with Sweden. We haven't fought since like 1700 something, I believe. That's the longest
well then,
period
by
of
all
peace between our
means,
two countries.
you guys need to get on it. We are waiting.
It's kind of like Germany. That had been quite a suspiciously long time. I'm just saying, if you're near the Ardennes, just peek behind the trees. Maybe the Germans are getting ready.
Now, I know you hate the walking, hiking simulator, but are you going to light the beacons, you know, like they did in Lord of the Rings?
We call them Bauner in Denmark, and I think we have a few of them still, like from olden days. We have, because then you turn them into like lighthouses. So you had like the same warning system, because we are a coastal nation. So if we saw people attacking by the coast, we'd lit a fire, so everyone could say, "Oh, don't go over there," or maybe go over there and beat the other one. I don't know. I don't know how you do war. And
I don't know. I'd see a big fire and I'd be like, "Does anyone have s'mores?" Also, some people are attacking, but also s'mores.
yeah, it's Nick might have something to say about that. He would say thank you, because deep down in every Swede is a little kid who wished to be Danish again. Can you all teach us that? Well, no, because we've actually we joined you. We become the merry band of war makers. So every time you go, our little army says, "We have 500 extra people. Can we send them?" And Americans look and say, "Yeah, sure." That's
Every little bit helps.
Heidi. It's not true. Whatever I make up about Jamie when she's late, don't trust it. Jamie hasn't left her house since 1992 when she went to an NSYNC concert. She was one of the first people who saw Justin Timberlake before he became famous. So,
Actually, that is kind of true.
Yeah, she
I met
watched.
them. I met them when I was like 14, and they were like nobodies.
So she was in before Hi turned into Bye on that farewell tour. So that's
Jamie, you tell him no to the perm. Did you tell Justin stop, for the love of all that is Cheetos? What is this
Right.
ramen noodle perm?
Well, you know, back in the day, the ramen noodle bleach blonde hair was cool though. Everybody had it.
We actually are known for
sad?
our military prowess. We are actually known as some of those you really want with you when you go to war. What time does the hearing start? It starts 4 minutes ago.
Ah,
So
so can we address the snack attack in the room? Did you see Sarah Boone's? And I put him on my thumbnail, but the 5 peppermints, 2 juice boxes, 3 bags of chips, and a partridge in a pear tree, and possibly a freshly squeezed gelfling. I mean, ma'am, what in the like, my blood. First of all, if she is truly diabetic, which she has claimed, then you wouldn't want to have all that processed sugar and not have your medication and not know, you know, exactly all that crud that you're getting, you know, how to dial that in. But just no.
well, you forgot that she also wants either a bag of candy or a Pop-Tart. and cookies.
Oh yeah,
remember, Sarah Boone is gluten. No, that's not called gluten allergic.
It was
it's
soy,
called
wasn't it?
She says no. She's a celiac, so she can't do gluten, except when she wants what the gluten bag contains. Then she doesn't have her allergies.
Yeah.
Then she can't do soy unless she wants what's on the soy menu. Then she's not allergic to soy. And Jamie haven't even noticed. I decorated for Halloween, but sorry, Jamie.
What is that?
It's spider webs.
Did you cut them out yourself?
No, of course. Jamie, have you met me? I don't
know. They kind of look like paper ones that you like cut, right? Am I crazy?
No, it's you buy them at the store, and there were supposed to be spiders you can put in it, but I didn't find the spiders until after I taped them. So, and I have a little skull up there and a little pumpkin head.
Where?
I do so much for you, Jamie. Do you ever say thank you?
I don't. Oh, okay. They're very, very. They're orange, but I couldn't tell what it was.
Bye, Jamie.
Oh,
we can't have it both ways. We can't say Johnny Depp was brilliant for having candies on his table and Sarah is not because she wants juice boxes and potato chips. Well, at least he had grown-up stuff. She's asking for the same as most feral child wants for his lunch.
I mean, I was very tempted to get all of those for props, but I am trying to be much more conscious in my food kind of choices. And I know that a box of Pop-Tarts, which brown sugar frosted, are the only ones that you should ever buy. Mo's opinion here.
Cookies and cream are pretty dang tasty too.
Oh yeah, but if I were on a desert island and I could only have one, I would still stick with the brown sugar. And
you can't really
I knew that it would be, it would be dangerous if I had those in my house, because 3 a.m. me would be like, just have a Pop-Tart. She sounds kind of like Sarah.
Just less alky. A little more sugar. She's not the one waking you up at 3 a.m. saying, Mad Dog 2020. Let's add it.
Well, she's getting snacky. She's all stressed out, so she wants all the kid snacks.
The difference is Boone is on trial for
83 slices of cheese somewhere.
Yeah,
96 slices of cheese. Please, our girl is a scrounger. She's on trial for redrum. JD was a civil suit. Yeah, that's a little one. What is everyone's thought about unshelled sunflower seeds? I would love to see Sarah go through a bucket of those. No, you need the shelled one so she can sit and do the.
Ugh, I hate that. But
as a person that has no idea how the depths of hell opened up, and we get all these creators that make loud food noises in their microphone, and that's considered entertainment. No, I don't want Sarah. She already is offensive when she's talking. I don't need to hear just all the mouth noises. No.
Mr. Owen, object, Mr.
I
oh, stop it.
Mo for president, I will make that illegal. It's wrong and it's terrible.
Thank you, Henry's mom, for becoming a member. Ugh. I didn't think you could eat in court. Normally you can't, but I was watching, I can't remember what trial I was watching the other day. Someone just put a little snuff bag in because you have to testify. You need a little nicotine in your system. Next, she'll ask for a picnic basket. She'll ask for the cooler that that was in the Benefield trial where the judge said, "Bring a cooler.
Bring yourself a cooler, a small fridge. It's fine."
Yeah, and some clothes. It's cold in court.
Yeah, some extra clothes.
Well, Maria, she is innocent.
I wanted to make sure they were
guilty.
They had everything they needed.
What?
I like that guy.
Yeah, I mean, think of the jury. Won't someone think of the jury?
Exactly.
In all fairness, no lawyer would want me on the stand without nicotine. And a few Yinglings. Sarah needs a mini fridge and an air fryer. We got
Oh my
a
gosh.
trend kind of going in Denmark where kids I've talked about you finish elementary school and then you go into one of the three, either business, uni, or a real education preparation. And people were sitting on TikToks and the Snapchats and whatever the kids use these days and made food in class. And I'm like, why didn't the teacher go down and just give you an adjustment 5? That's one of these.
Oh, I was wondering. I was like, this must be a new thing.
Yeah, it's just to adjust your attitude. Tailgate party at court. That could be cool. Joel from Surviving the Survivor has been in Voir. He says she literally never stops moving. I'm sure that will get better after she eats a truckload of sugar. Yeah. Mm-hmm. And again, she just seems everything must go by Sarah time.
Yeah,
well,
and
technically,
it is kind of ridiculous that she believes she's above being treated like every other prisoner who has to go to trial. They have to get up early because there's extra searches, which I can imagine makes for an incredibly long and tedious day. I'm not discounting that. But this is every other prisoner goes through the same things, but Sarah, doesn't count herself as that, I guess.
Mm-hmm.
96 pieces of cheese in her bra, 96 pieces of cheese. Take 95 pieces of cheese in the bra.
Hey, don't joke. That's how she got to be a C cup for a little bit until it all melted.
No, it's that weird.
No, it'll harden.
It'll harden. So it's probably to keep a lift.
That's like probably a way to make a jailhouse wonder bra. There you go.
Rumors has it she did it to be perky for Pena.
There you go.
Okay, Jamie, I will go on Beauty on a Budget, and we will figure out how many cheese slices it takes to go from an A to a C.
Up yourself a couple cup sizes, yeah.
Tomorrow on Beauty on a Budget, cheese C cups. How much do you need? Jamie it'll be on her OnlyFans account because we can't really show it on the YouTube. But so tomorrow it'll be Beauty on a Budget on Jamie's OnlyFans. And Brandon says, "Who needs nicotine when you can pop into the bottom right corner and throw back a beer?" Well, I'm saying, why only do one when you can do both? I couldn't see Valhalla without a Siggy Sig and a Drinky Poo. I met Valhalla. He's a nice fellow to be around.
Is he?
Yeah, but Valhalla would go in and he'd just pop a Yingling and be like, "Look, I'm real stressed out," and everyone would be like, "Oh, it's Valhalla. It's okay."
Yeah, even the judge would say, "Okay, you get a wrench. You get a jury wrench. Don't worry about it." Next day, he'll show up 20 minutes late and go, "I'm sorry. I was so stressed. It's fine. Don't think about it."
No, Valhalla would be like, "Have you tried a Baconator? Like, I was on my way to court. I was going to be on time, but you can't say no to a Baconator. Here, judge, I brought you one." And the judge is like, "You can judge this time. Here's my robe. Have fun." That's it. We need Valhalla reporting from every court trial because I need that in my life.
I mean, everybody needs them in their life for real.
Let's make him the Katie Caruso of court TV.
Outside the courthouse, in the courtroom, yeah.
Yeah. Valhalla, what happened in court today? I don't know. I got here a little bit late, but commissary, great. They have this vanilla Coke. Really like that. But did you see the trial? What?
Oh, I didn't make it in there.
Yeah.
Wait,
just-
I was here for a trial?
Yeah.
It's boring.
That's it. We need to forget, oh gosh, Judge Judy. We need Judge Valhalla. I would pay to see Valhalla judge, all sorts of petty, issues.
Hmm.
Well, I can get a PO box, but I was looking into it because Vices have that one where he can kind of thingy and use it kind of like a PO box, and it'll ship to you, and you don't put my name on it and stuff like that. Every shipment going to Denmark would add $50. So I'm thinking, I need a lot of T-shirts before I get a $50 payday. But no, I just need to become a millionaire, and I'm going to be it after this trial. And then I'll move to, maybe I'll be like 3 months of the year in the US to begin with, and then we'll see. I would really love to be on an American time schedule. I did that Diddy show. Not many people showed up last night to see it, but I did a Diddy show at midnight. Imagine being able to do like a 10 to 12 show, go to bed, get your sleep, get up, be ready for court the next morning. I sleep 6 hours. I can do that. I would love to be on American time. I could get so much done.
Well, speaking as an American on American time, I don't manage to always be efficient.
Yeah,
No, but
The grass is not always greener over here.
No, but I have that weird schedule where I sit here every morning and think, really annoying that no one is up at from 3 to 7 a.m. American time. I have a lot of good ideas at that. I made Drunky the Bear at that time. Sarah is in the county next to me. I'd smuggle her some beef jerky, but I don't really like her. Smuggle her some cheese slices. He would love that, Danielle.
Yeah.
Sadly, no Danishes, because Americans have that weird thing of putting cheese in it. So they are banned on this channel. Thank you, Marie Moss. We
Americans
try to
are
fill
weird.
the time when nothing goes on in court, and I am watching on Lawn and Crim, and they haven't said anything. They haven't changed the time. So it'll happen when it happens. Jamie, is something going on the Twitch thread? I can't see Carly Caruso.
Carly Caruso.
Whatever her name is.
I love when you just make up names.
I still get a plastic pilot wing every time I get on a plane. Next day, you show up with a baby goat just to mess with the jet. Yeah.
I could see
Valhalla
that.
would have a little petting zoo in the jury box. Did you watch his stream yesterday? He was out walking his goats.
No, I did not get a chance to do that, but I will have to, because if he can herd a bunch of kids, maybe one day I can with my children.
I think goats are easier.
Yeah.
Chelsea B, I could actually see something like that Sarah woke up this morning thinking, oh, I'm really effed. Can we please get those 15 years back on the table?
Nope, I don't see
No.
anything. They just had the same update that it starts at 9:30.
Yes, I made a Twitter troll list. I made a list yesterday on Twitter. Normally, I'm left off on every grift list, but yesterday I made a list of
Ooh.
people who didn't stop other people from harassing people connected to John O'Keefe. And I said, I think I pretty much have said that every time I covered anything. Don't harass people. Don't go looking for people. Stop being an a-hole. There's not enough a-holes. In Denmark, we have a saying, there's more a-holes than there is layer cake. So stop being one of those and become a layer cake. Luckily, I'm a baker, so I can turn a-holes into layer cakes.
Oh my god.
It's the Sweeney Todd we all need. Bakers, the Baker's Bakery of horror.
I know what I'm giving Baker for Christmas. I just figured it out. $1 million. Thank you, Dave. That's nice. Maybe it's the keys to his treehouse so I can live there for 3 months of the year.
Aw,
Ooh,
that'd
that would be
sweet.
fun.
Then I can live there, and then I can sit and say, "Hey, Jamie, you want to come out?" No, you don't.
No. No. that
Not
doesn't
enough
sound fun at
vanilla
all.
in the treehouse.
Not enough.
Hey, Panilla. What size T-shirt is Baker? I'm a fat. I am a double XL American. European, probably all the X's. Little D got me my WrestleMania shirt in double XL, and it fits perfectly.
I'm a fat. What is
That's hilarious. Baker.
Oh man. that was
But I
funny.
am.
You say curvy or fluffy.
No, I say erotically fluffy.
Erotically fluffy.
I'm stealing that.
Merch on my store if you need it. They should be showing the pre-trial hearings, which isn't pre-trial hearings, but motion hearings. They should be showing that, but again, I am looking, I'm updating. It was supposed to start 21 minutes ago. Ain't nothing happened.
Maybe Owens is crying in the background, holding a Pop-Tart for Drunky the Bear and like, please take the flea deal. Please, I got you.
Probably.
Your Pop-Tart. Please.
Judge Kranig is hearing other cases, then motion hearing will begin. Thank you so much, Marissa.
Good job.
Love Jamie's laugh. Everyone does, except that one person who complained that Jamie laughed. Please leave them alone.
Oh, that was
I had
fun.
one complaint from Mo. Now HR has joined us today. I have a complaint.
I'm all ears.
They liked our content yesterday with the audio recordings, but there's too much commentary. So I said you can just find the audio recordings on the link that I
Yeah,
put
we
in.
actually promoted the channel that just had the, raw audio if you wanted it. And which was, I thought,
that was
awesome
video.
because, it was a smaller creator. I subbed, but she did go out and get all of these audio recordings and, but you are never going to make everyone happy. I don't know if you don't want commentary. Look, I'm wearing a Plague Doctor sweater. I mean, I am a deeply unserious person. It is what it is. I never market myself as hard-hitting legal analysis because I'm not a legalologist.
Whenever you sit and try and do ChatGPT to help you with a description, they always join us for legal analysis. Nope, take legal analysis out. I don't do that. Hard-hitting breaking news. Nope. I make fun of most things, try to make it a little more lighthearted, and remember all the stuff you forget. So if you ask me, I can tell you it was a C cup Jamie will be doing tomorrow in cheese in Beauty on a Budget on her OnlyFans. See, I remember stuff. I forget where I claimed Jamie was earlier, but that's what we do.
The beluga whales.
Michael Bublé.
That's why I'm here.
Yeah.
Michael Bublé. I love
But
Michael Bublé.
You are on a comedy channel, not comedy. You're on a commentary channel where the kind of idea is we have a good environment going. We had a nice chat going. We're watching a trial. We're discussing a trial. It's not like because law and crim exist for those people who think, by golly, these folks talk way much. I like them when I can just sit here with 24 hours of breaks and just look into the wall.
Yeah. I mean, if you would like to just add your own commentary, go there. They have an interesting chat. I don't think they've met a state prosecutor they don't love. So
I'm so
I love when
I'm dying.
I love when I break Jamie. And it's usually, I'm over here thinking, what did I say?
It's the way you're saying it. I don't know. It was just really good. Oh, that was
Her
perfect.
neighbor said she stinks. Yeah, that's why she wanted to have a shower when she gets home. She complained yesterday that she got a shower, even though the judge made a special permission for her to take a shower because showers close at 9 in the prison. She got back at 9:30, got a shower. She complained about that one too. She's always complaining.
Yeah.
Hey, Rian Morgan Thomas.
I just imagine the look on Judge, Browzo Justice face, like, because I can't remember where I put my eyebrows right now, but yeah, this heifer needs a shower. Yeah, I'm going to go ahead and call over to the jail now.
If Sarah would quit boofing cheese, she wouldn't smell. If the suitcase don't fit, you must acquit. Hey, Betsy. Love the color of Mo's hair. It's kind of a manga hairdo you have right now.
It is, but I will probably going back to a color that, well, somewhat resides in nature. In theory.
Poisonous Frogs has that color, so.
I do try to warn people.
Welcome in chat, Robin S58. Chat's nice. Please contribute as much as you want. Zach, he's a part of the ADA program of every streamer when they start streaming are allotted a special person, and Zach is my special person. So whatever he says, don't take it too closely. I get a small government grant for having him in my chat.
You get a small government grant.
And that's how Dave's bread got stained to. Nope. Always read line 2 in Brandon's text.
I love that. I'll pull something up and I'm like, oh, well.
Probably shouldn't have done that one. Did I just call Mo poisonous? No, I said her hair color is the same color as Poisonous Frogs. It's not the same. Don't you start no beef, Jess. Well, I only get the grant for Zach. The rest of you, that's why I grift so much. What the duckling? Good morning. And Special K. You do write the short channel. And the fish he's kissing is 6 inches.
What?
Zach is kissing a fish in his picture. But
Isn't that
again,
cute?
It's the false perspective that, yes, Zach, it's 6 inches. Sure.
Well, I've never caught a fish, so it's one more fish than I've ever caught.
Yeah, well, Zach probably didn't do it either. He bought it at a store and then he kissed it.
Oh my God.
I'm 30 minutes behind, just home from the hospital and resting. Glad for the fun and company. Oh, I hope everything is going fine.
Yeah.
Sarah testifying will be worse than Tellus. I didn't watch Tellus that much, sadly. I saw bits and pieces of it over on Brandy's channel. He seemed like he was also an odd dog. He constantly looked like he was just about to cry. And he wore lifts in his shoe or something like that.
Oh, he was the one that, took off his shoes. Like, it can't be me. I'm shorter.
Yeah. I am kind of a Ron DeSantis. I use 5-inch lifts.
You're tall. What are you talking about?
Who's tall?
You are. I thought you were saying you were short.
No, I said Ron
Okay.
DeSantis.
We have a serious question to ask. Brows of Justice. Silver fox, brunette.
Jamie, you are the beauty expert.
I know. I need to know which are going to be better brows of justice.
Are you
Brown
just
or
putting
gray?
brows on, or are you going to be wearing a wig along with them?
Well, I'll have the male wig that I have that Mr. Mo asked me not to wear around him because I look like a more testosterone Haley Joel Osment, which is weird. He's stopped asking questions now. He really has. But we have, you know, 2 different brows for brows of justice.
I really like,
And
I'm partial to the gray brows.
I kind of am too. I think it gives him a bit of dignity.
Yeah. It's a little pop of
These will be for Sarah.
dimension.
Let me take that off. One of each because our. Both.
Sounds good.
Diverse brows of justice. Do we know what Tillis may get for his sentencing? Oh yeah, he's getting sentenced today. No, again, I didn't follow the case. I know nothing about it other than a journalist was red-rummed. That's all I know.
Yeah.
And he was found guilty. I don't know anything
wore
about
a
it.
crazy outfit. That was all we looked into.
Yeah, because he looked
Crazy
kind of like
outfit.
a Vietnamese grandma in Denmark because they wear those rice paddy hats and those big trench coats all the time, every year.
Look, those bulbous, bulging Manson lamps, he is one of the people I would profile in Walmart. Like, I'm not going down the chip aisle with you. I know you have someone locked in your basement, possibly, and I'm just not going to chance it.
Mm-hmm.
That's probably a very good idea with some people like, but he seems like the way he was also sexually harassing his coworkers, and he didn't seem like a fella you wanted to work with. I'm just saying.
Nah.
Well, unless you were the chick he was having an affair with, because apparently he gave her all the commissions-based stuff, or however you do that thing, all the fees.
Oh. I love that. I put a post in to say, please show Mo some love, and then I forgot to put the link in. I am.
You are better than me. I stink out loud. I have the greatest mods who know how to put links in. So when I ask, they can help because I'm like, I don't link. I don't remember how to do this.
The judge accidentally forgot to tell the clerk's office he couldn't do first appearances. Oh, something just happened. Something just happened.
Woo.
We do have un signal pour la cote. La cote, il signalé dans la...
Ooh. I'm surprised they still have analog clocks in courtrooms, considering most people can't read them anymore.
Well, it's another one to show you justice is coming because of the TikToking. And left it at his house, his boss baby, according to his coworkers. That was so stupid that I'm going to do a crime. I'm going to cut up the evidence and hide it in my garage and in my couch.
And then go, somebody frame me.
Okay, Baker, you have had children. You know when you take those couch cushions out, you are like, they stopped making ding-dongs this flavor. When did we have these? Oh, we're showing her legs.
Bound chicken, wow, wow. Wicka, 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 bound chicken, bound, bound.
Giggity, giggity, giggity.
Oh my gosh.
And yet her hair hasn't moved.
Is it coming? Oh, and his daughter is sitting there smiling enthusiastically at her. Is he coming back with the 80s pulled up? Oh, they're fist bumping again.
Are we going to get the fist bump of justice? Like, you know,
No, he just fist bumped her arm. She's probably going to sue for sexual harassment. I did something I shouldn't do this morning. I read the 6 new lawsuits against P. Diddy. For those of you who didn't get there, only 50 people was there, but you can go back and watch it later. It's only like an hour. A guy describes how he knew there was 3 assailants when he got
Yikes.
because he could tell the difference. So he knew at least 3 guys. I'm thinking someone is doing his butt kegels.
So he was like, I'm pretty sure it wasn't 1. And I'm not going to rule out 2, but I'm sticking with 3 because it's a good prime number.
Oh, she's so happy. I can't wait.
She thinks she is gonna nail this. It's just crazy to me.
She's gonna be. Why have they been coordinating every single time? It's so bizarre with the clothes. I don't know that. And oh yeah, clap your fellow lawyer. He's probably sitting there thinking, well,
Don't touch me.
Hopefully there's a paycheck in this for me sometime. Imagine giving her 3 weeks of your lawyer time. Is it how much? 450, 500 an hour you bill? And you are spending 3 weeks on this lady who will then probably sue you, go on every national outlet telling you how stupid you are when you lose her case because it's unwinnable. Maybe it's unwinnable. I don't know. Innocent until proven guilty.
Oh, well, and I speak, this is the only
Is
kind
her,
thing I will say.
Sorry, Mo, Jamie, now I have my female panel. Is this part shaved? With her side part? It looks like she shaved a little bit of the...
It looks like she's just
nest.
thinning up front. It looks like she's thinning maybe and kind of does a comb over to hide it a bit.
And she does have the good old, there's something about Mary swoosh. Maybe it's Pena who makes her hairdo that way. And she has the Donald Trump wave on the side.
Okay, I will only say this in her defense. Look, as a mom of 6 children, I have not slept well in nearly 18 years. Nothing can help those under eye circles. I have gone to Sephora. I have tried to act, and ask the weird people that smell like all the perfumes. And they're like, use this. I have spent more trying to hide the fact that I haven't had a good night's sleep, which is why I wear glasses. So, even Elizabeth Arden couldn't help her.
Yeah, Jamie, even you, with all the budget money in the world, couldn't get her to not look like an entitled B-word.
It'd be rough.
That would be a lot of spackle
annoying it
and
is
contouring.
she doesn't have a single visible gray hair. Yeah. She's 20 years older than me, and I have more gray hair than she has. Probably. She got a shower and her hair said, what is this? I'm falling out. As a person who also, I do that when I feed kids. I do I don't know, sometimes I just do weird mouth movements as well.
Well, yeah. I'm surprised. Where are her peppermints? How is Owens going to keep her under control?
Maybe it's like before I stream, I toss, Molly has some chicken meat and something wrapped together. I toss her one of those just to calm her down. It's probably something like that. Maybe she has that prison makeup on. Garth Brooks is an optometrist if you need help. Well, he's fond of glasses.
America's Best team up with Garth Brooks seems a little shady now.
Be funny.
This is
Garth
why
Brooks
I am not allowed
of glasses.
This is
P.
why
Diddy
I
had
wouldn't be
some.
allowed into marketing. Because I'd be like, yes, we are getting Garth Brooks and we are getting Sarah Boone to market our suitcases.
Yep.
Yeah, that should be OJ for the gloves. Sarah Boone for your traveling
Yes.
goods. Why is his daughter not a paralegal? Why she was at the table one day and now she's just sitting behind them, and this paralegal is in the, do they call it the pen or whatever they call it?
Well, doesn't she have like a third lawyer now? So not only is there Owens, and I'm forgetting this gentleman's name. I only remember him having terrible audio. That one Zoom call.
Yeah. Oh, she got 2 glasses of water. She's gonna spill one of them on the microphone at some point.
William J. for the state.
James Owens on behalf of Sarah Boone.
Hey, Dory K. Been a minute. Missed you.
I do.
Ma'am, good morning. Can you state your full name and date of birth for the record for me?
Sarah Boone, 10-10-7-7.
All right, Ms. Boone is seated at counsel's table wearing a gray suit and a white blouse. She is out of custody and unshackled. Mr. Beck, you arrived late, sir. Can I get your appearance for the record, please? All right, thank you. All right, we're here on a litany of different matters, multiple motions in limine. The state's motion in limine to exclude battered spouse syndrome evidence or exclude mention of battered spouse syndrome evidence until the defendant testifies to a justifiable use of deadly force, filed October 6. Defendant's response to state's motion in limine to exclude battered spouse syndrome evidence or mention of battered spouse syndrome evidence until defendant testified filed October 15th. And then the defendant's amended response to same, also filed October 15th. The defendant's motion in limine filed October 6th. The state's response to same filed October 6th. State's motion, objection and motion in limine to exclude decedent's medical records filed October 14th. And then the parties' objections with regard to specific exhibits that may be sought to be entered at trial. The court has reviewed everything and reviewed all of your case law, and we're ready to proceed.
Showtime, baby. Pop those bottles, folks. I'm assuming everyone got their booze. And over on most channels, just to get us going, Curio. Always a good show.
And thank you for being a member for 10 months, Jude.
Let's get to it. Do it.
I believe we should probably proceed first on the battered spouse motions first. So state, you may begin. And I also have reviewed as well the excerpts of the deposition of both Dr. Warner and Dr. Harper as identified in the state's motion.
Why are we whispering? No, nothing interesting has happened. We're just getting started.
I do want to see how she reacts if this does not go her way. If they are in fact forced not to bring any of this up until the point at which she testifies. Because she will, I think, then have to change her their strategy to have her testify first.
Yeah. We should have a poll on how many outfits she's going to have. A new one every day, or how soon they recycle. I think she'll probably have 3 outfits.
It looks like a coordinating suit kind of set. So you have pants, you have a skirt, you have a shirt, all kind of in the same, or a blazer, all in the same kind of color
What-
family.
For the
and then you
record, I'm
can
having
just-
Madam Clerk mark A, B, and C.
What is
for
it you say? You need
identification
3
purposes for
suits
this
and
hearing.
5 shirts, and then you can
A
press
is a
every
copy
day.
of the defendant's statements that she made on body-worn camera to Deputy Sheriff
Saving
Caleb
my drinks for verdict
Rodriguez
watch.
on February 24th of 2020, as well as the interview that she provided to Detectives Kopsel and Lowen on February 24th, 2020, and February 25th,
Hello, Helene.
2020. It is an identical exhibit as to
Helene
what was
got
provided
out of
to
bed
the court
with me reading
for
that
review
story
in
about the
chambers
guy
as a courtesy
from the
before the motion to
morning.
suppress statements.
I'm sorry.
As well as what is entered into evidence for that motion to suppress statements hearing that was held. State would move A for identification purposes in as 1 for the purposes of this hearing.
Responses to what was pre-marked as A.
No objection.
All right, what was pre-marked as states A will be received without objection as states 1.
B for identification for purposes of this hearing is the deposition of Dr. Harper. We would move that into evidence as states 2 for the purposes of this hearing.
Any objection?
No objection.
All right, what was pre-marked as B will be received without objection as states 2.
C for identification for purposes of this hearing is the deposition of Dr. Werner. The state would move that into evidence as states 3 for the purposes of this hearing.
Any objection?
No objection.
All right, what was pre-marked as state
Exactly,
C
Dory.
will be received without objection.
I know your lawyer. It's a joke. Lawyer, you know, and Brandy and Surviving the Survivors podcast should all be at the courthouse. So there's a full plethora of people covering this and being there live. So you will get a round-the-clock coverage of Boone the next couple of weeks. So you are indeed lucky potatoes.
Mm.
Yes.
As states 3.
Your Honor is familiar with all those exhibits and has been able to review them prior to the hearing, so I will just proceed to the legal argument.
You may proceed.
Your Honor, this is a motion to eliminate. We are asking for a pretrial ruling based on the proffered statements that the defendant has made, which should, in good faith and reliance, the state should be able to assume that that will be her testimony at trial, given that her latest version of events was just given to our expert last week.
In Denmark, you are a lucky potato. Don't ask why,
Oh.
just accept it. It's a healthy kartoffel.
So we are asking for a pretrial ruling
She has leg irons on.
if that is the evidence that comes in at trial, will she get a self-defense instruction? Will she be able to then open the door to all the things that come with self-defense, such as reputation evidence of the victim for being violent, which she may or may not be aware of, that's not required under the law, or prior instances of violence between she and the victim, or the victim and anybody that she is aware of, because that goes to the reasonableness of her perception of an imminent threat of death or great bodily harm. We're not asking to not be allowed to talk about these things during voir dire. The defense cited numerous cases and spent some of their time in their response about the ability to voir dire that. That was not the purpose of our motion. I don't think we mentioned voir dire.
Thank you, Patches.
Because we understand that the defendant can, like any other witness, change her story again. So we understand that we both, on both sides, we intend on spending a great deal of time on it as well for the state of Florida. We need to explore these issues during jury selection. But what we are asking from the court now, preliminarily, is if that is what the defendant is going to say in trial, and I'm not asking the court to make any credibility determinations about one version or another. We're asking you to treat this just like a...
Wasn't it only her hand restraints, and the judge said she will have her leg irons on, but there would be something to cover it, to not show it to the jury? I believe she has her leg irons on, but she has no cufflinks.
I think that Owens might have said, you know, she's not violent. I've never seen her be violent. And I think the state was like, fine, we have no objections. She's closer to you.
Yeah. And
Yeah.
and Brandon, there will be a quiz on the last day. Jess didn't. I don't know if Jess has made the bingo cards for opening statements, but we have to figure that one out. I trust Dirksmeyer because that's a German name and they are always correct. No restraints.
C4 motion or a motion for summary judgment in a civil case. If this is what she says, does this amount to what they are asking for legally? And it's the state's position under the case law that no, because under her statements that she gave to the experts, there was no overt act taken by the decedent on that day. There was no overt action. And that's what's required under the law to trigger her response of acting in self-defense. There was nothing creating an imminent fear of death or great bodily harm to her until she committed 2 forcible felonies and a non-forcible felony. What her testimony was is, we were having a good day. Now, what's different, and again, we're not asking you to make a credibility determination about what's different, but what is different than what you had heard at the motion to suppress is, we were having a good day, but I'm on edge every day because of past instances of violence, including an instance the night before. But we were having a good day. We're out on the porch. There's a dartboard out there. There's puzzles that we're doing. We're doing arts and crafts. We're doing everything to keep him preoccupied so he doesn't get sad or upset. Interjecting with some phone calls to his family, which she knows would potentially upset him, but that's her testimony. And then eventually it comes to a point in time where they're sitting on the couch and he reaches over to her and says, "Tag, you're it." And she apparently runs up to the shower to hide, and he apparently gets into the suitcase to hide, and it's not clear who's it.
Thanks.
Eventually, she comes down out of the shower after she says she was getting cold up there and sees him in the suitcase and zips him up. And at the time that she zips the suitcase, what she describes as nearly entirely shut, but 2 fingertips could get out. Mind you, a 103-pound man, 2 fingertips. They're laughing. It's all fun and games still. There's still no overt act taken by the decedent during this entire calendar day to put anybody in reasonable fear, objectively reasonable in fear of imminent harm, of great bodily harm or death. And it's only when he begins to say, after she has zipped him up into the suitcase, and again, she is saying that she did not have malintent at that time. When he starts to say, "I cannot breathe," now she describes to the doctors that she does have bad intent, and she wants him to feel what she has felt in the past. She gets angry, is her description. She shakes the suitcase, she beats it, it falls over, it flips over, he sticks his fingertips out, she hits him with a bat. So she's now the initial aggressor, and we'll discuss jury instructions as we get closer, but she's the initial aggressor, and she has now committed forcible felonies, aggravated assault, and aggravated battery, stating that I only intended to keep him in there for a couple of minutes. I believed he could get out. She never perceived, according to her, that he would die or face great bodily harm. And she just goes upstairs knowing now he's mad because she won't let him out. Now, because of the actions she took as the initial aggressor, she is facing death or great bodily harm from the decedent if he gets out. And she completely expects him to get out because her testimony is that he could get 2 fingertips out of the zipper. So, Your Honor, under the law, the state understands. We are deeply, deeply thoughtful about this request because of the risk of error. But this is just one of those cases, like the cases the state cited. There is no self-defense if that is what her testimony is. And therefore, the jury should not hear about any prior instances of violence, any reputation evidence, any battered spouse syndrome, unless and until there is testimony that is self-defense that's recognized under the state of Florida's laws. So what we are asking for is a ruling that if, and this is a motion in limine, and a motion in limine is, hey, this is what's proffered to the court prior to trial. If this is what comes in at trial, this is the court's preliminary ruling, unless something changes. What we're asking for is a preliminary ruling that if that is what her testimony is, then we should not be allowing introduction of past instances of violence, reputation for violence.
Stop vacuuming, Jamie. It's a.
I'm not doing anything.
RJ, send it to me either on Twitter or Discord DMs. I do read my email sometimes. Self-defense story is a complete fabrication. Yes, because you have to be in danger right now. It's other BS, the self-defense claim.
Yeah.
Go ahead, sir.
Or battered spouse syndrome evidence. And furthermore, what the case law supports is our request that clearly this evidence can only come from her. There was nobody else in the apartment or townhouse that night. So she should have to testify before any of those things come in. And her testimony should meet the requirements of an overt act before any of this testimony comes in. It should not be allowed to come in prior to her testimony. And under the case law that the state cited, it's not unfair. It's not forcing her to testify. She chose to raise battered spouse syndrome. The state completely understands we have the burden of disproving self-defense beyond a reasonable doubt. But what the case law says is we shouldn't have to combat this. We can't put the toothpaste back in the tube.
Yes, this is a motion hearing. We need to get all of these motions out of here because if everything goes well, we will be starting tomorrow after lunch with opening statements.
Yes.
Until she actually puts forth the self-defense that justifies all this. So that is our request. We're not making any requests about voir dire because we understand she can come in and testify differently yet again at trial. And that's a discussion we'll have to have as well about how that will occur. The state's position is that if she changes her testimony yet again, she should have to give a narrative testimony. No attorney should be allowed to participate in putting forth new testimony about the events of February 23rd. Thank you.
All right, thank you very much. Response.
Oh, I really wish I had an emotional support beverage. Oh, it's not Owen, so I don't have to deal with his voice.
I'm a little confused, but I want to make sure, so probably can save some time here. My understanding is what the state's saying at this time, that there's no objection to raising this in voir dire to see how the jury would react or their feelings about it. So that's not it. So what that leaves me is, I guess the state's trying to say there should be no mention of battered spouse or anything like that in opening statement.
That wasn't my takeaway either. My takeaway from the motion and the state's argument today is from a evidence perspective, concepts or testimony or even opinion evidence about battered spouse syndrome cannot be raised, including any of the reputation or specific instances of conduct that are contemplated by self-defense until there's a factual basis for it. My understanding of the defense's Dr. Harper's deposition is that the basis of her opinion, and please correct me if I am wrong, but my understanding is that the basis of Dr. Harper's deposition is based on her 4 or 5 interviews or sessions with Ms. Boone as to what transpired on the day and night in question. Is that accurate?
I need to confirm.
Sure.
We read this how long ago? 2 weeks ago?
Yes.
And they still haven't figured out what the motion is about? You are not allowed to mention battered spouse until Sarah Boone takes the stand and testifies that she's a battered spouse. That's
Well, damn, there goes my, this lawyer will know what he's talking about, and he's not Owens. And this guy's like, look, I'm a little disconfabulated here. I'm a little,
They use big words.
irritated.
Yeah, it's not. They used words like limine, motion. I'm not sure. What the doctor? Keep up the excellent grifting. Thanks for the coverage of your girlfriend. Love your channel. Thank you so much, what the doctor? And Jess is already preemptively putting a little thing in the swear jar. I think this will be a very, very hard case to get through without emotional support beverages and a few choice words.
Yeah, I'm pretty sure that you're going to be able to come to America like first class on the swear jar proceeds.
Well, the problem is her plausibility goes away when she claims that he was in the suitcase, so there was no imminent danger. So yeah, I'm telling you, they aren't trial lawyers; they are plea deal lawyers. And the judge is saying, "Nope, I didn't get that one." Yeah, and she has to admit to killing him to use that argument, because again, there's no self-defense unless you admit that you did it. You can't claim it's an accident. You can't accidentally defend yourself in this way legally. You will have to have a conscious mind doing it. Don't think about it.
Yeah, and that the judge has to explain to the lawyers, no, this is what this means.
Well, Brandon, then you can unalive them if he breaks out. You can't say, my neighbor was yelling at me.
Judge, if I could have you repeat that question.
Sure. So my understanding, well, let me ask you, I'll have a more of an open-ended question. What is the basis factually of Dr. Harper's opinion? So if we were at trial right now for the purposes of this exercise, and you were going to call Dr. Harper to testify, what is the factual basis component under 90.702 in order to get her to testify? We're not dealing with her CV, her credentials. I'm not sure the state's going to have any position with regard to those, but let's just assume the state has no objection with regard to her credentials and that she is in fact an expert based on her knowledge, training, and experience in her field. What is step one under 90.702 to allow her to testify? What is the sufficient factual basis of her opinion?
Judge, I think her opinion would be based on several different things. Mainly, one of the things that her opinion would be based on is her interaction over the course of time with our client, Ms. Boone. That's one. But Dr. Harper has also reviewed other evidence in this case that helps her form the basis of her opinion, and also her knowledge of battered spouse syndrome. That has to be taken into account because, quite frankly, Judge, people who suffer from certain things, they don't know. That's why you have to, like, if you have to get an expert opinion as to someone's mental health situation. I mean, a person doesn't really know that they're suffering from a mental health problem. They have no idea in a lot of circumstances. What they do is they get evaluated by a doctor. The doctor has experience of what signs to look for in these things.
I'm smelling toast.
And getting those signs with what they told and outside sources too. They are able to make a determination based on their training and experience. So,
but based on the Akendo case, which is cited by the state as to what what battered spouse is it's an ambit of self-defense. So under the statute, are you traveling under 776.012 as your basis?
None of her lawyers know what the Kendo case is. They think Kendo is something you play at a casino that they spelled wrong because it's called Keno, and they never ever heard about case law. This is going to be the longest 3 weeks of what? At some point they will ask, but Judge, have we established subject matter jurisdiction? It'll be the first lawyer to ask for a subject matter jurisdiction ruling.
And if we go on the premise that people don't know that they're having mental health problems, why would they go see a doctor? If you're just assume that you're normal, the logic, this is hurting more than The Acolyte. And that was made by Hollywood. This can't be real. The Matrix is glitching.
They do have legal assistants. They have 2 legal assistants. Owen threw that attorney under their own bus. Well, It's your job to get ready for. He knew this day was coming.
For self-defense.
Day for being a member of
Yes,
Mojan
but
for
this
9
is
months.
this is the problem that I'm having.
You and her have now
Self-defense
a child.
is a defense. It's an affirmative defense that's available to anybody. It's based on the evidence at trial.
But what's the overt act? Because in reviewing Dr. Harper's deposition, there were specific questions by the state inquired of her about the language, specifically in those statutes, about the imminence of fear. And she was unable to answer those questions. So my question really is, what's the overt act by the victim which would have given rise to self-defense? Because the case law, taking aside the state's case law under the stand your ground concepts, which I find distinguishable, because under 776.032, there's a specific statutory scheme for pretrial stand your ground motions. So I find those cases distinguishable for that very reason. But there's specific case law, bless you, there's specific case law that talks about in the self-defense realm that the state has cited to in their motion that an overt act is needed. What is the overt act?
Judge, the overt act has to come from testimony, and I agree in this case, but that has to be the testimony of Sarah Boone for that overt act. And that testimony can only take place at trial. In making a determination of whether to give the self-defense instruction, it has to be based on the evidence presented at trial.
I agree with you on that. I completely agree with you on that. And the case law is clear that if even there's a scintilla of evidence, I have to give that instruction. But we're not dealing with the jury instruction right now. What I'm dealing with right now is pretrial. The state saying you cannot proceed on battered spouse. There's two avenues in this motion. Avenue one is you cannot proceed with battered spouse because of the factual reasons based on Dr. Harper's deposition as to what she's going to be the basis of her opinion. Battered spouse cannot be entered. Alternatively, you cannot talk about it until there's foundation. That's my takeaway from the state's argument, that before battered spouse is argued or provided or opinion, there has to be that foundation to it. And the linchpin for me is the overt act issue. That how can we have anybody testify to opinions or any of the reputation or specific instances of conduct that we permitted until that overt act is established? What's your response to that?
My response to that, if I'm understanding you correctly.
Because, if you need to reframe the question, please.
Because it's procedurally. There's no way that we could come in here and put Dr. Harper on the stand before Sarah Boone. It just doesn't work. Because to even establish the relevancy of Dr. Harper's testimony, Sarah Boone, who's the only witness there at the time, I agree with that with the state, has to present evidence of self-defense. Has to present the evidence of the court talking about that overt act. It's not based on what the doctor perceives or what the doctor was told by Miss Boone or what questions were asked at that.
Thank you for being here for 12 months, Jude. Been here a while. Yes, you have. And we have enjoyed everything. Jamie, when you're doing you, I don't know what you do, Jamie, but you rock, girl.
Oh, Jude, you're the best. I'm always doing me. What do you want me to do?
Giggity, giggity, giggity.
That deposition? I don't know. Mr. Owens took the deposition. Questions, though, at the depositions are limited and the doctor answers. But that's not what this has to be based on. What it has to be based on is what does...
Yes, this is the defense lawyer who had a bad audio connection. I think he wished he had a bad audio connection right now because he has no basis for his argument.
Ms. Boone, in this case, testifies to on the stand. And if any of that, excuse me, if any of that presents a scintilla of evidence to award the self-defense instruction, then the self-defense instruction should be given. That's the first step. Everything follows after that, Judge, because this isn't a situation where I think it's appropriate to make a pretrial ruling, because the ruling has to be based on the evidence that comes from that witness stand. Now, any of the evidence...
No, a pretrial ruling can't be based on something that happens at trial. You are still talking about what is been put into the jury instructions. We are talking about a pre-trial ruling. Jamie, you'll do the rest of the day.
You know what?
Subject to cross-examination.
Maybe we won't run errands. Maybe we will break out the Boone's Farm, because either that or I need to find my brain slug headband because I think I would understand this better if I didn't have full use of my faculties.
Yeah.
Possibly.
A nation, impeachment, anything like that. But that's a wait for the jury to determine. But as to the admissibility of the evidence, it has to start with Sarah Boone. A judgment can't be made or a decision cannot be made until the testimony of Sarah Boone takes place at trial. This is just procedurally incorrect.
Any other arguments, sir?
No other argument.
Thank you. Rebuttal.
This is procedurally correct. Parties are allowed to get motions in limine based on the proffers of evidence that have been made prior to trial. Apparently, opposing counsel has not read the depositions, or he clearly didn't attend them because he was not there. But the court has before it the statements that Sarah Boone made when directly asked, what happened that day? What happened next? And there was no overt act taken by the decedent on that particular day. What they want to do, and what is not permissible under the case law that I've cited, in particular the one that says you get a threatening text and then 2 days later you can't go slit somebody's throat because of the threatening text 2 days earlier. Not to dehumanize Mr. Torres at all, but to give you this analogy. If somebody owns a bad dog and that bad dog bites and that bad dog is bitten in the past, but on this particular day, the dog is just doing arts and crafts and puzzles and hanging out, drinking some Woodbridge Chardonnay. And you put the dog in the suitcase, and then the dog barks because it's in the suitcase and doesn't want to be in the suitcase when it's zipped up. That triggers you to, I remember when the dog bit me in the past. You can't, that's not how this works. That's not how self-defense works with or without battered spouse syndrome. There has to be an overt act. You can't bootstrap and make up a fictitious act of violence on that day based on the past violence. That's not what the case law allows. And no, the state is asking, unless they are saying that testimony will be different at trial, we are asking for the court to prevent them from saying anything about this during opening statements, because they will know based on the court's ruling what your client has already said to Doctors Werner and Harper does not admit self-defense evidence into this case. So that's what we're looking for, is that ruling. If this is what the testimony is at trial, then self-defense is not going to apply. And all the ancillary prejudicial things that come with it, reputation evidence, past instances of violence, battered spouse evidence, is not coming in either. Now, if they make some statements and promises that they cannot fulfill in opening statements, then that'll be on them. King versus State will allow us to point those things out to the jury, and it will not be burden shifting. But that's what we're asking is, this is a proffer, just like any other proffer testimony, like a sex crimes case
in there
where we file a deposition of a Williams Rule victim and ask the court to rule prior to trial, hey, if this is how the Williams Rule victim testifies and it's clear and convincing and it meets all the standards under 404 and 403, can this prior act of sexual violence come in during the trial? This is what parties do all the time, is get pretrial rulings on crucial matters like this. This is a crucial matter because the tip of the iceberg is the second-degree murder. The rest of the iceberg, the 99% of what has been going on for the last month and a half, is the self-defense that just isn't there. It wasn't there under her former statements to the police, and it's not there under her current statements. So we're asking for a ruling, a motion in limine, which is subject to change based on the evidence at trial. But if this is what the evidence is at trial, the court should not allow any of the battered spouse, any of the prior violence, any reputation evidence in. That's all we're asking for.
Okay.
Thank you.
All right. Thank you.
Jude Courier meant, when are you getting your own YouTube place, Jamie?
I'm never going to move out of Baker's YouTube place. Yeah, right. Who knows? Who knows what the future holds for Jamie? Who knows?
Beauty on a Budget will be a subsidiary of Baker Media. Then the dogs play some games and have some Woodbridge.
Oh my gosh, I was trying to recreate that velvet painting of the dogs playing poker, and
that just threw, I didn't even know it's a thing, because then once he said the dogs are playing games and have some drinks, I was like, wait, what? And then the dog gets in the suitcase.
Lawyer, follow me. Go with her interviews conflicted themselves because they all weren't true. She was shocked and scared he could still punish her. Her statements weren't the truth. Brandon, you are putting way too much effort into it. It's easier to just say, but Judge, you can't do that. You have to wait till trial starts, and then we'll see if what we claim in opening statements might come true. I don't know, maybe. And Mary Murphy, Baker, thank you for your comedy, kindness, and mods. Well, I can't, I don't answer for my mods. Some of them are okay. And some of them are.
Mhm.
Jamie.
Just gotta respond.
Excuse me.
Briefly.
I'm the best.
Judge, it is not the responsibility of the defense to present their case at a pretrial hearing. However,
But the problem is in the state's argument, in the case law, which the case law has been presented by the defense in your filings, are not germane to the issue. We're not addressing jury selection and the standard of proof and the burden with regard to self-defense, you establishing a prima facie case, and then the higher standard that the state has to overcome it. There's no dispute as to that. The issue is the necessary predicate to establish battered spouse. And the state's argument is that due to the lack of an overt act, based on what Dr. Harper has relied upon, to wit, the multiple interviews or sessions with Ms. Boone, that element seemingly is lacking. We all know what elements are, right? If it's a negligence case, it's duty breach causation. In this case, it's the elements based on the jury instructions are George Torres is dead, she caused the death, and it was done so in a depraved heart manner. I may have butchered that last element, but those are the elements that need to be established based on the jury instructions. Similarly with self-defense, the case law talks about the overt act.
Yeah.
And then the flashpoint of the defense's argument is that the facts which were provided to the expert, who in turn will testify to battered spouse, that flashpoint, that overt act is lacking.
it's not, Judge, but I find myself in the position now.
You're muted.
I bet the judge loves lawyers saying, no, it's not, Your Honor, you're wrong.
This is like when I try to ask youngest most feral. Okay, so who broke into the house and wrote Griffin in permanent marker on my new mixing bowl? Well, it was totally a robbler. So someone just broke into our house. And he's like, yeah, like, duh, I said it. What do you mean? Why are you questioning this?
Yeah, it's just, Judge, you don't know the law. I never looked at any of the case law, but I'm right. Let's get on.
Gosh, that pause face
our
too.
view
He is.
of the overt act is. That's what this has put. This is what this motion has put us into. So it's an exercise of the state to learn our theory or our view of the evidence, because the overt act is in the physical evidence, and the overt act is mentioned to Dr. Harper in the deposition as to the reaction of Ms. Boone by the overt act. And the overt acts, I have to tell you, his hand is coming out of the suitcase. That means he's about to get out of the suitcase. Now, based on history and everything else, she doesn't have to wait to see what's going to happen when he gets out of the suitcase. It's clear what's going to happen when he gets out of the suitcase. It's followed up by...
Then you can do it when he's out the suitcase and attacking you.
Yes.
I can't send someone to unalive Brandon because I know he will drink me to death when I go play golf with him and Tom Gillis. I can't preemptively unalive him. I have to be in an imminent fear of my life. This is a stupid argument, and again, I'm not a lawyer.
Well, he is purposely being obtuse and thinking they're arguing. He is on some subsection over here where he is not even on the same itinerary as the rest of these people. And if, again, that's like saying, you know, I put someone in a container and I saw they were going to get out. Well, if she hadn't done these preceding crimes of, you know, keeping him in there and then grabbing the baseball bat, I mean, this hurts. My brain hurts, and that
This is going to be worse than
when I try to do Sudoku.
We thought, oh, Sarah's getting lawyers. It's going to ruin all our fun. We haven't watched 5 minutes without stop yet. People are probably going to write in comments, you comment too much.
Physical evidence, because there's a picture provided of Mr. Torres's hand that shows a mark on that hand that it matches up with the bat. That's the overt act. It's like a gun.
Yes, me too.
Okay?
You
don't have to wait for them to pull the trigger. You don't. And it's based on all the evidence in the case, just not testimony, but also physical evidence that might support the testimony.
Thank you, sir. All right, the court has had the opportunity to review the motions, review all the case law. The state's motion is going to be granted in part and denied in part. With regard to the state's request to exclude battered spouse syndrome evidence outright, the motion is denied. As to specifically Wagner, for the reasons identified in the court's prior rulings as to the concept of argument, again, there's no outright evidence of accident, not argument, excuse me. As to the state's reliance on Lantz, L-A-N-T-Z v. State, 263 Southern 3rd, 279, no argument of self-defense was ever offered in that case. I find the cases of Reed v. State, 213 Southern 3rd, 1110, Rudin, R-U-D-I-N v. State, 182 Southern 3rd, 724, State v. Woodson, 349 Southern 3rd, 510, and Morris, 325 Southern 3rd, 1009, distinguishable as all of those cases were traveling under 776.032 for stand your ground hearings. It's undisputable that an overt act needs to be provided under the Holland case by the Florida Supreme Court, 916 Southern 2nd, 750. I find the departure from the essential requirements of law argument by the state factually and legally distinguishable, as there was a specific statute for the state obtaining medical records as relied upon in Roberts v. State by the 6th ECA in May of 2023 WL 3262633 at pinpoint site 2. So for those reasons, the state outright motion to preclude or exclude battered spouse syndrome evidence in toto is denied. With regard to the second portion, that excluding mention of battered spouse syndrome evidence until there's a basis for it, the court's going to rely on Ladd and Medina, specifically that there needs to be testimony provided for the expert to testify to the battered spouse syndrome, and there needs to be sufficient predicate established for that self-defense. So I'm going to preclude any mention or testimony in the form of expert testimony as to battered spouse until that necessary predicate as identified in Ladd 564 Southern 2nd 587 has been established. Any questions with regard to the state's ruling? I'm sorry, the court's ruling, forgive me. Defense.
Meaning?
You want to mention an opening? You can mention an opening. Certainly, I'm going to allow you, and the state at this point has no problem with the concept of battered spouse being addressed in voir dire. And even if the state objected to it, I most likely would overrule it based on the litany of case law that you cited, that you're allowed to dive into those things during jury selection. As to should the defense put on a case, the predicate under Ladd needs to be established before any expert opines to battered spouse.
My concern is open. Can it be mentioned in?
Yes, that's your decision. That is your decision if you want.
So it can be mentioned in opening, but they can't put it on as a defense before they have made a foundation for the battered spouse syndrome, which should be Sarah testifying she's a battered spouse. I bet you they will F this up because they want to use Sarah as the last witness.
Absolutely. Given what they've changed about this, my strategy going forward, if I had an option, is I would, save my opening statement for the start of my case. We've seen defenses do that. And then I would have Sarah come on first. Again, it's not ideal. I would maybe see if she had like one of those happy CBD gummies for like puppies, and you could just wrap it up in cheese and give it to her before she goes on. But, she is the one that will lay the predicate. She has to say in there, I intentionally did self-defense.
Yeah, not intentionally did self-defense.
And they are going to confuse this because when the judge asked, and they should have said, okay, does that mean that Sarah will have to be the first witness in order to bring this in? Or what are you going to count as the predicate? And I'm sure there's, explanations, or lawyerly people will know what those sort of requirements are. But, oh, Lord.
Yeah, but the problem will be, again, she has changed her story more times than I've changed underwear in my life, which is true. And she will maybe change the story again, and then they will have said in opening statement, and then the state can say, oh, by the way, they never addressed that battered spouse syndrome they told you about. It's such a minefield, and I don't think they're smart enough to get through it.
I want to mention an opening. There's no preclusion from you doing that. Okay. Any other questions with regard to the court's order on that matter? State.
No, Your Honor.
Defense.
No, Your Honor.
Okay, thank you. Moving now to the defendant's motion in limine filed October 6th and the state's response to same. It looks like we've reached some level of common ground with regard to that motion. The court is going to grant the motion with regard to the statements on page 69 through 71 of the transcript of the February 25, 2020 interview between Detectives Lowen and Kopsel and Miss Boone from page 69, line 6 through page 71. That will be granted to the state not objecting to same. That
That's,
leads us to
I don't like my
the
neighbor.
statements
He's
on
an
page
idiot.
53, line
Her getting
11,
her new
53,
eyes.
line 13, line 14, page 55, line 24, page 56, line 1, and page 92, line 15. With that, defense, you may proceed with any argument similar to the last motions. I have reviewed all of y'all's case law.
Find a microphone.
The rule of sequestration applies to testimony of other witnesses, not to anything else.
Response?
Find a microphone.
I can see. I said there's no state witnesses.
So that's a no. You may proceed with any argument, Mr. Owens. Yes, sir.
I've gotten myself a lapel mic because I want to stand and do more active-y things. They're about $20.
I have reviewed the 2.8 instruction prior today. Thank you, Counselor.
Judge, the problem is the state attorney, when they filed the response, they didn't include the highlighted portion that's italicized at the beginning. Police opinions and statements regarding guilt are generally inadmissible and must be redacted from recordings introduced into evidence unless redaction would render the defendant's relevant admissions incomprehensible. If a recorded interview cannot be appropriately redacted, the trial judge must, upon request, give the following limiting instruction immediately before the recorded interview is played for the jury. That section, which is comments directed to the court, was not placed, to my understanding, in their response.
Okay. Any other argument?
Judge, this was a 2-hour interrogation that occurred the day or two after the event. And the day prior to this time, or that morning, the detectives uncovered the 2 videotapes, the 2-minute video that Sarah Boone had recorded, and then followed up 11 minutes later with a 22-second video that she recorded and they found on her phone, which I believe from the interrogation discloses that Sarah did not remember making those recordings. But the purpose of law enforcement's position about having her come in was to interrogate her in an attempt to get a confession from her to the murder. They spent 2 hours trying to do that any which way they possibly could. And the law says that they're allowed to use, and I cited several cases. I cited the Smith v. State case, the ODEH, O-D-E-H v. State case, and the Eugene v. State. And in those cases,
I didn't see a citation to Eugene. I mean, Eugene's included in ODA, but I don't.
Eugene is found. Do you need the cite?
I have it. It's included in ODA, but you did not cite it in your motion.
Okay. Eugene is 53 Southern 3rd, 1104. But law enforcement are entitled to use a variety of interrogation techniques to try to elicit a confession to the crime. But as in that case, in spite of the detective's efforts, Sarah Boone refused to admit that she was guilty of the murder. But as a last resort, Judge, and it was a 2-hour interrogation, it was the last portion, at least the last quarter, maybe less than that, is when the detectives made some statements that are highly prejudicial to the defendant and tend to be opinion and tend to invade the province of the jury. And that's why this special jury instruction 2.8, recorded interview, effective law enforcement statements on the defendant, has that italicized portion in there. And the statements we're referring to under my motion, the second section of evidence to be excluded, page 53, line 11, well, he's dead as a result of your actions. And then paragraph 9, line 13, he's dead as a result of your actions. She responded, line 14, I understand that. And then paragraph 11, page 55, line 24, I have one last question. I mean, you realize you're the person that killed him, right? Sarah Boone responds on page 56, I thought about that. And then lastly on page 92, well, intention or not, here's the detective distinguishing how he interprets the law. and her culpability. Well, intention or not, George is dead, and you act like when you say unintentionally, that absolves you from everything. That is exactly the kind of opinion testimony from law enforcement that the courts are worried about. The probative value of that type of opinion testimony about her guilt is outweighed by the prejudicial effect. Thank you.
There's a corrective jury instruction that the state
cited
in their
in the
motion.
jury instruction that would be read. I didn't feel it necessary to include italicized portions of comments to the court because this is what would get read to the jury. Those statements are designed to get responses from her. They did get responses from her.
Let me ask this question first, Mr. J. Do you disagree with counsel's representation of what is reflected in the Q&A at that point in time?
To the extent that he is making the argument that they're expressing an opinion about
No, the words, not his opinion, not his thoughts or what it means, but the black and white verbiage is reflected in the motion. Is that what's reflected in the recording?
I'm accepting that he would not misrepresent that.
Okay, thank you. You may continue.
And as far as the last line on page 92, line 15, if something's designed to get a response that a normal person would respond to and there's no response, that still makes it a relevant statement. He's not giving an opinion on the law. He's giving an opinion about her reactions to this interview and trying to get a reaction from her when she says, well, intention or not, Jorge is dead. You act like when you say unintentionally, that absolves you from everything. He's not stating that that is a legal defense. He's just commenting on what has transpired in the 92 pages of the interview. So we defer to.
Well, she did think that.
Okay, thank you. Any rebuttal?
Unintentionally meant she'd get out of it. Duh.
Just for the state attorney not to put that in there, the italicized portion, where Supreme Court is giving instructions to the court with those comments. For them not to put that in there.
Sir, shut the hell up. You don't put any
The Jackson case speaks for itself.
law.
The court has reviewed it.
Thank you.
All right. Thank you both for your motion, your motions, your responses, and the case law. The court is going to grant the defense's motion. I disagree with the defense, or with the state rather, as identified in their response, that the only issue is battered spouse. The issue is one of the elements is cause, and those three statements go specifically, I believe, to opinions as to the cause of Mr. Torres's death. So the court is going to grant the state's motion, as under the Bush case cited by the state. Law enforcement's opinions are inadmissible due to the prejudicial effect that they may have. And I do find that this is expression of law enforcement's opinions as to the guilt of the accused. As such, the motion is granted, and those will need to be redacted from. I apologize. Thank you. The defense's motion is granted for those reasons. Any questions or clarifications with regard to the court's ruling? State. Questions or clarifications with regards to the court's ruling? Questions or clarifications with regard to the state's ruling? Or the court's ruling, excuse me. All right, that takes us now to the
I got a feeling that
state's objection motion limited to exclude decedent's medical records. I've reviewed that as well. State, you may proceed.
Kristen, just the other night, I received 550 pages of medical records regarding the treatment of Mr. Torres from two incidents, one in 2017 and one in 2018. The third email that I received from Mr. Owens purported he believed that they had attachments. They did not. I replied to him as such, and I've not gotten any additional emails with attachments regarding the medical records. So for the purposes of this hearing, all I'm arguing about is the 550 pages that I have been provided. One of those instances.
I love all these little catty, oh, that's not what the state laws, the case law says. I didn't get the evidence he was proposed to send me. Oh, that's not what it says. It's a little B-ish, but I'm here for it.
And he has to deal with Owens. I mean, he gets a bunch of motions with no case law, and then Owens goes up there and says, but I don't think it's fair to Sarah.
Yeah, but do you have case law? No.
What are you talking about?
What if any is case law?
A narrative being given by the patient, Mr. Torres, that he had put his hand through a plate glass window.
This is the 2018 incident, correct?
Yes. And his wife, the following day, made him go in and get treatment. There was a 4.5 centimeter laceration that required 2 sutures. There is no history in the narrative about any violence that the decedent had committed. So I anticipate that Ms. Boone, when she testifies, will give us an explanation about how this was an instance of past violence that she was aware of by the decedent. So making that assumption, then what the state is asking for is the 57 pages seems excessive. This jury is going to have a lot of information to weigh and consider. Not every page of these 57 pages is relevant. What is relevant is, yes, he came in for treatment, that narrative, you know, and the history that he gave of.
Who's winning right now? The state is winning most of their things. They can talk about battered spouse, but it demands, before they can put witnesses on about battered spouse, that Sarah has taken the stand. And if they mention it in the opening statement and they don't address it, then the state can hammer on that in their closing statements. That's the big thing. The rest of it was, as we knew, of course, the police officers can try and elicit any kind of statement. It's wildly proven that ain't no law for the law. So they can try everything they want to get you to testify you did it. And the only thing that they got redacted was, my neighbor is an illegal.
Well, also the cops kind of saying, okay, well, you can say unintentional all you want.
Yeah.
But, you know, that doesn't take away that you're the reason he's dead.
Yeah.
So those statements will be removed also from the interrogation. But this was a last-ditch attempt for the state, or for the defense, to nerf as much as they could that interrogation.
Yeah, he ordered some of the interrogation. Some of the interrogation is where she tries to rat out her neighbor to ICE because he didn't want to let her use the toilet.
Putting his hand through a plate glass window, and that he got sutures. That corroborates her testimony. I understand why she will need corroboration for her testimony to bolster her credibility. So if she testifies that way, we get it, but it's just excessive, and it's going to be confusing. They don't need to read 57 pages of all of his treatment. The second batch was 487 pages regarding an incident on Christmas of 2017, when what the decedent reports in the narrative to the hospital is that some unknown men jumped him and beat him up. Being a victim of violence is not relevant in this case. I expect there will be a story based upon the testimony that we've taken from the experts that this all happened at a family gathering, and one of the decedent's brothers learned from Sarah Boone that Sarah Boone said that the decedent, had committed violence against her and then beat him up. That's not the same ilk as corroborating violence with breaking windows or whatever it is that caused his laceration, whatever she ends up testifying to about the 2018 incident. But this incident, it's irrelevant that he got beat up by his brother. It's irrelevant that he suffered the amount and severity of injuries that he did. That is not required to corroborate her testimony that, I mean, I don't even know if it comes in, that she makes an out-of-court statement to the decedent's brother that something is true that happened in the past. That seems like classic hearsay. I'm not sure how she would get that in. I don't know that the 487 pages is needed to corroborate that. And if the court, like I stated in my response, if the court believes that it is necessary to corroborate her story that he did get beat up by his brother, then again, there are narrative parts of these medical records. Generally, I would say in this particular instance, it was a handful of pages that give the narrative as to what happened. And I don't know that it's relevant what the treatment was that he received, but there's narratives of that as well. They don't need to be bogged down with 487 pages of toxicology reports, nursing rounds, just all the things that I'm sure the court is familiar with from your past experience that are in these medical records. It's unnecessary and it's prejudicial. Its probative value is substantially outweighed by its prejudice, confusing, repetitiveness, as I outlined in my response. So that's our position.
Thank you, sir. Response.
Judge, as you know, we got on this case about 45 days ago, and I can't tell you how many pages.
You chose to get on this case 45 days ago. You knew what you were getting into. Stop using it as an excuse. You wanted the fame. You wanted to become a YouTube lawyer after this. So you wanted to get her into a plea deal. Just admit it. You are out on your depths, but stop excusing yourself with the time you chose when you joined this case. I'm sorry.
And you didn't he didn't, well, no, but he obviously didn't do any cursory background like, hey, I can take this pro bono case. How absolutely done is the judge. Oh, he wrote a 15-page motion of why we're not going to lollygag anymore.
Yeah.
Oh, well then maybe I'm not going to get a continuance. He just again, you saw the ride, you saw the circus, and you decided not only to buy a ticket but become the ringmaster. I don't feel sorry for you. Stop.
Yeah, exactly.
Discovery there is that we've had to go through. And 2 or 3 weeks ago, the state attorney provided us over 500 pages from either telephone calls that my client was involved in from the jail or tablet communications, which are kind of like emails or text messages. And that hasn't been narrowed down, but that was given to us. So that's something else we had to stop and go through over 500 pages. And they haven't narrowed that down to which ones they believe were incriminating to her.
Understood. But respectfully, that's not the issue before the court right now.
That. But yes, the medical records are going to be narrowed down. And yes, we would have to make some tie to Sarah Boone's testimony to whether or not their medical records of the decedent, Jorge Torres, are admissible to corroborate her stories about the incidences of violence and whether they match up. But yes, I agree there's going to be a narrowing down, but it's kind of premature about that. They've got several volumes. I assume before they introduce something, they're going to have to narrow it down. Did y'all not have Jorge Torres' medical records prior to me sending them to you? No, we didn't. All right, well, we took the deposition of Dr. Harper. And as you know, Judge, these forensic psychologists, when they're trying to make an opinion as to battered spouse or whatever the case may be, they rely on their assessment involving the personal contact and interviews they have with the client. But a lot of it is any other collateral evidence that tends to support it. That involves arrest reports, that involves court records, that involves psychological notes, that involves medical records. And at that time, when the state took Dr. Harper, our witness's deposition, she said, yes, I did rely on Jorge Torres' medical records. So they were well aware.
That doesn't mean they come into evidence.
I know that. I didn't say that. But they were well aware that that's one thing that she relied upon. A lot of that collateral evidence doesn't come into. It's going to be.
I need to jump into the breach here. I understand all of that. I understand that there's been volumes of documents that have been provided between both parties. And I understand, based on my review of the highlighted portions that the state pointed out in their motion, as to what Dr. Harper relied upon. None of that is germane to the state's argument. And you've admitted that there needs to be a narrowing down. So let's just kind of compartmentalize what we've got here.
So it's premature. It's premature. I agree it needs to be narrowed down. And then based on Sarah Boone's testimony.
You are the proponent of the evidence. So you have to establish relevance.
I agree.
And you have to establish that it is not so substantially unfairly prejudicial.
Yes.
That the prejudice does not outweigh its probative value, including but not limited to the other identifications in 90.403.
Yes, sir.
So my question is, sir, with regard to the 2018 incident of the fist through the plate glass window, and I can't recall 40 some odd pages, I think the state identified as that.
47.
What of those 47 pages is germane to an incident of violence that may be needed to establish the self-defense concept of those 47 pages?
It will be relevant after she testifies about that incident.
All 47 pages?
Maybe not all 47 pages. I've agreed that some of it needs to be narrowed down.
Okay, well, what of it needs to be narrowed down? Since we have some level of common ground here.
The case is not going to be presented, I would assume, until next week. So I've got a little bit of time. I'll let the state know.
That's not how this works.
I can't let you know today, Judge. I'll narrow it down, or we'll talk in the next couple of days.
Well, the state's position is that the narrative should be permitted as to the 2018 incident, the why Mr. Torres was there. But the nursing rounds, the charts, the follow-ups, treatment, anything in the future other than the 4.5 centimeter laceration that required 2 sutures.
The intentional, unintentional defense.
I understand the narrative as to what transpired. What else is relevant? And I haven't seen these 47 pages, so I'm not sure there. I'm relying on counsel's representation.
I don't know. I'd have to look at them. But in one of the medical records, Jorge Torres was over a 0.31 BAC. Every time.
In 2018?
2018?
I'm talking about the 2018 incident with regard to the plate glass window.
Look at the records, but there is other evidence in those records that's going to be.
What if any does that have to do with a 2-year later incident that he had a 3.1 BAC? It's
also George is not on trial here, so that could be considered prejudicial. I mean, yes, it sounds like he was incredibly drunk, but you can't just bring in, well, I knew him one day and he was really drunk and he did this. She has, the narrative seems fine. The judge is trying to tell him, narrow it down to the narrative.
You can let in that he was an alcoholic. You can get that in. But what, if any, does it have to do with you're trying to use it for? It's again, they have been combing through everything in their hopes that they could find that little bit of straw that they could cling on to. Like Jack was clinging onto the door when Rose said, "Ladies first."
Relevant after she testifies. That's when she gets beaten, when he gets really drunk. Or that's when he does something violent or threatens to do something violent when he gets really drunk.
But that's going to be her testifying that he didn't put his hand through a window then, but destroyed her hand, his hand by beating her. Sense it makes notte, as they say in Latin.
No, and how look, maybe as a deeply unserious person, it is a little bit odd that my biggest fear is looking like an a-hole, you know, when I'm representing myself as an intelligent person. So how could you get up there and not know? You knew this motion was coming up. You could say, I agree with the state. We'll pull this. We do want to see if we can get maybe his toxicology in. But, you know,
what we really want in is his toxicology level, and that Sarah will be testifying the injuries actually was from him beating her to show a pattern of abuse. Gracias. That's what they
well,
want.
He's acting like he has all this time too. And it's like, you're in the middle of jury selection, guy.
Yeah, he's like, oh, we'll tell him when our case starts, when this judge has
we'll
been
let you know in a
clear.
couple days. Like, what?
Yeah. Well, before we end the case, we'll probably mention it.
Yeah, we'll let you know.
Yeah, that's what Brian also said. She had marks after he was defending him against her. It's good thing it's breakfast lunch soon, so my brain no worky.
In one of those incidences, he was over a 0.3. When he gets over a 0.2 to 0.3, that's when he gets angry. He's fine up until that point. We're going to establish that. I don't want to put on my defense today, but Judge, there is going.
How are you going to establish that he has a certain level of intoxication before he gets beady?
Yeah.
Does she alcohol test him and say, "Oh, you are at 2.9. You know, no more drinky poo for you the next hour."
They have an at-home, you know, breathalyzer test just to make sure they can maintain their drunkitude, but at a manageable level.
Yeah.
Yes, Tellus has, but I haven't been covering that. Brandy will be covering the sentencing, I believe.
To be relevance to more than just the narrative of those medical records. I'll narrow it down by Friday. That's the best I can do.
Okay. What about the 2017 incident, 487 pages, and those documents pertaining to the facial reconstruction and anything thereafter? What does that have to do with anything?
Same thing. You know, it's going to be based on her testimony, and then the judge is going to have to make a decision about whether that's admissible based on her testimony about what happened.
But what does the facial reconstruction, surgery, pre-surgery, post-surgery notes have anything to do with whether or not that incident actually took place?
That's going to depend on Sarah Boone, depending on what her testimony is, and you'll have to find, based on that, whether or not that's relevant.
I self-defended me because a doctor wrote in a note, he has a broken jaw, we need to fix that. We fixed his broken jaw. We had to set it. He had an orbital bone fracture.
And he's like, no, Your Honor, when Sarah testifies, all this will make sense. At least that's what she's told me.
And probative to the case.
That's not how motions in limine work.
I don't know what else to tell you, Judge. She's going to have to testify, and then we'll make the arguments as to the admissibility of that.
I'm struggling with understanding
the YOLO defense.
I can understand BAC results. I can understand that based on Dr. Harper's deposition. I can understand the narrative as to why they were there. I don't know what are all in these records. What does nursing rounds or pre-op, post-op of facial reconstruction surgery have anything to do with an incident that purportedly took place on December 24, 2017? How is it relevant?
Some of those may not be. Some of the records may be relevant, depending on Sarah Boone's testimony about how what happened to him was tied to what he did to her.
Okay. Anything else?
That's it.
Response.
I really don't like the
discovery
state's
responsibilities in a
tie.
criminal matter are not equal. The state of Florida has a duty to disclose anything that anybody knows or may reasonably be calculated to lead to relevant information to the defense. The defendant's obligation is to let us know what they're going to use in trial. So for them to come in today on the third day of jury selection and to tell us that it's premature to ask for what is going to be their actual evidence in a trial is wrong. They got these records, and I understand that they're the 9th set of attorneys for Ms. Boone, but the defendant got these records in 2022 or 2021. And they just get disclosed to me overnight a couple of nights ago. In their discovery responses,
he doesn't understand
in the First Amendment, Second Amendment, Third, so on and so forth. For weeks, they were telling us that they didn't have them and they were waiting for them, but they were sitting in Ms. Boone's box, apparently, that Billy Lane had acquired years ago. So
she's getting
it's not premature to ask, and it's not unfair to ask for what is going to be introduced in this case or attempted to be introduced, particularly given the court's rulings. We had rulings from this court, I think you entered it August 5th or August 6th, setting forth a schedule for what are you both. And the state too, we both disclosed what are we actually introducing. The state has actually narrowed down the digital phone evidence from the defendant greatly to about 160 pages of the PDF from the thousands that it was, and handful and a few dozen pictures and videos. We have done everything we can to narrow it down. We're not asking for much here.
She's going to ship business.
Not asking for much. And just to bring the point about the BAC, Jorge Torres had a 342 medical blood, so there's probably some conversion, 10-15% for legal blood, at the time that he was admitted for his facial injuries. That would be a different picture than on the date of the plate glass window. On that date, again, I expect that the testimony from the defendant will be that he was the aggressor, the violent one, and his blood alcohol level would be relevant for the plate glass window one. But I'm struggling to understand what his BAC's relevance is if we're all at a family gathering at the Torres's and she says something that triggers one of his brothers to violently beat him nearly to death, what his BAC's relevance is on that particular occasion, unless her testimony is the decedent was being violent with her that day, and that's just not my understanding of how the deposition's read. So, Judge, we're not asking for much. I don't think Friday's sufficient. We're attaching jeopardy to this case as soon as we swear this panel in, hopefully tomorrow morning. Thank you.
Thank you. All right. The court has reviewed the motion and has reviewed both the arguments. I'm struggling with the relevance on some of these things. So I'm going to grant the state's motion in part to the factual narratives as to why Mr. Torres was seeking treatment. That will be admissible. I'm going to overrule the state's objection with that, and I think they've conceded that that is relevant. Information regarding blood alcohol content in both the December 24, 2017 incident and the 2018 incident, I find potential relevance. So I'm going to overrule the state's objection with regard to those. However, the balance, I'm going to sustain the state's objection and grant their motion in limine unless there's evidence provided in the defense's case in chief that make these other documents relevant. Because at this point in time, it is unclear to me how the balance of other...
What was that shy little smile?
Okay, that was her hearing. When Sarah gives testimony, it means it's the truth. And so she's thinking in her head, I'm going to be able to testify and I'm going to be able to drag him. I mean, I will call him anything but George, pretty much.
Anything but a white woman.
Hospital records, nursing rounds, pre-op, post-op, the surgery itself from the 2017 incident are relevant to a fact of consequence.
She's like a bad Care
any
Bear.
Of the material allegations the state needs to establish or any material allegations the defense needs to establish for the purposes of self-defense. I'm not foreclosing you, but there needs to be something for you to link these documents together.
Her Care Bear stare is
any
booze.
Clarification or questions with regard to the state's rule or the court's ruling? Defense. All right, thank you. That now takes us to the objections to the evidence. Give me a moment. We have the defendant's objections to state's digital exhibits filed October 15th. The state's state's response to defendant's 5th amended reciprocal discovery exhibit list filed also on October 15th. I have reviewed these. I'm a little bit of a loss in the state's response because I don't know what items 1, 2, et cetera are. It just identifies them. I'm not sure what it is that they are.
It's tracking their 5th amended exhibit list. As I pointed out before, it got really confusing because as they added things, it would not go to the end of the list. It would get put into the middle of the list. So I started over, scrapped my first response to the first amended one, scrapped my second response to the second amended one, both of which were filed on September 27th in a timely manner. And this is why my paragraphs start with 0 in my response, because they have a paragraph in 1A, and then they list the items, and I wanted to make it very easy and clear for the court to just be able to flip to what paragraph I'm talking about for each item, tracking their 5th amended exhibit list.
But here's the problem that I'm having. On September 27th, I see the notice of provision of defendant's 3rd amended exhibit list. When was the 5th amended exhibit list provided?
That might be a problem with them not filing things with the clerk of the court.
Okay.
I'm getting copies of some pleadings, but they're not date stamped with the clerk of the court's e-filing system on the top left. So I'm not certain that they've filed anything with the clerk of the court.
Here's the other problem that I have. All I see on my end is the notice of providing. It doesn't identify anything. It's a 1-page document. So it's hard for me to say what I know. You may have seen it, but the court hasn't seen it based on what's been filed.
I believe I would direct any questions about why that's not filed with the clerk of the court to the defense.
Okay. All right. I need clarification, Mr. Owens, as to when the 5th amended reciprocal discovery exhibit list was filed and what is in it. Because the notice that I see in the court file from September 27th is just a notice. It doesn't identify anything for me to line up item 1 and item 1 as to what they purport to be.
You're asking for when it was filed? We're checking on that. When it was filed. What was the next question?
All I have is a notice. So on September 27th, there was a notice of provision of defendant's 3rd amended exhibit list. And it's just that. What we intend on utilizing has been provided. I don't have anything else as to what those items are.
Okay. Did you want us to provide you with a copy of those to your JA?
Or you can send it to Madam Clerk and she can print it out to me, because I'm having difficulty lining up what these things are, because all I have in the court file is this was sent on this day, but I don't know what any of these things are.
We can move on to something else.
Unless we've got some housekeeping matters to address for this afternoon. But unless I'm missing something, the only other thing that we've got teed up to address this morning is the objections. Okay. Give me 1 second. All right. I got an email this morning from Juror Services. Juror number 551. I don't recall from what panel. No, I'm sorry. Juror number 471, panel 3, seat 48. Tested positive for COVID, and Jury Services has instructed him not to return. Juror number 551.
What was the first one?
Sure. Juror number 471, panel 3. That would have been yesterday morning, seat 48. Advised Jury Services this morning that he was not feeling well. After leaving the courthouse, he tested positive for COVID. I have instructed Jury Services to excuse him because we don't need that floating around. The other juror, 551, I don't have any other information as to what panel or seat. She took a COVID test and was negative. She is planning on reporting today. So due to the shrinking from 54 to 53, jury selection will take place here in 12 Alpha this afternoon as opposed to the 23rd floor. The deputies have already brought in additional chairs so that we can fit 53 people in here. That's the only other housekeeping matters that I have to address.
So they won't be streaming this afternoon. It's voir dire of the jury. I thought it was voir dire of the... Well, I just set up an afternoon stream that we don't need.
So are there any housekeeping matters to address from the state before we address the objections issues?
Is it wise to not utilize that expanded space when 2 of these panels, or at least one of these panels, is already exposed to COVID?
I'll just forget that I sent you a link, Mo. This is not...
Would it not be wise
you're
to use
looking
the
for.
bigger space?
I'm going to change it for tomorrow then.
One of our panels has already potentially been exposed to
Tomorrow,
COVID, as
1
we
o'clock
pack
maybe?
everybody in sardines.
I would say 1.
Response.
Okay. I'm going out on a limb here, but defense is going to say we've all been exposed to the coof. We must delay this another some days before we all know if we weren't all just exposed. We'll get those motions to you like 4 days into the next trial. How about that?
Yeah, it's going to be something like that. Absolutely cray-cray.
It will.
I have no recollection that you ever told us that. I'm thinking Jemima is again spinning a tale. She is always making up stuff. Jamie would have told me if I had misheard. Thank you, RJ, for gifting a membership to Goose Tools. Goose does not have teeth.
I didn't realize he was saying it was voir dire of experts because I knew it was the jurors. So sorry. I missed
For the
telling you.
experts, is it called a Dalbert hearing? Because I know I mix those up because they both start with D and Latin is weird.
No, it's a voir dire of an expert as well.
Oh.
You can do a Dalbert hearing, which is the same as a voir dire.
Oh. See, Baker's teaching me. I'm trying
and Jess
not
will
to...
now be writing in chat, no, it's not, you idiot. And I'll say, Jamie told me.
I'm just here for Jedi Jess saying all the mean things in chat I want to say out loud. I'm here for it. She's like my inner mean girl.
Yeah, what there means to question, yes, but it's the same as a Dalbert hearing, right? Where they ask an expert, hey, do you know what school you went to? Can we go back and talk about the 45,000 questions we're going to ask all of you? Well, we can speed it up. We are behind. Dilbert hearing. Yeah, it's that cartoon. It's a Dilbert hearing.
They just make you really question Mondays. They're like, don't you hate Mondays too? And I'm like, yes, this has been an excellent Dilbert hearing.
Are we ever going to get to trial? We will get to it tomorrow. Tomorrow. Is she trying to look like a lawyer? No. No, people have been saying that all day. She hasn't picked her clothes. This.
All right, court's going to take a 15-minute recess to address jury selection location this afternoon.
Oh, better listen to what he said because maybe it's important.
Okay. Court's going to be in a 15-minute recess. Thank you. Amended exhibit list. All right, court's going to take a 15-minute recess to address jury selection location this afternoon. And
my neighbor
to give the defense the opportunity to provide the fifth amended exhibit list. With regard to juror 551, what say the state?
No objection to the, if he doesn't have COVID, then I don't have a motion for cause.
Okay. Any response from the defense?
Well, they are on breaky time. She's not trying to look like a lawyer. They are trying to dress her. Again, we talk about this a lot of times about what's going on with the dresses. Some defense attorneys will try and dress their clients. We saw that in the Benefield trial. Try and make her look as small and fragile as possible. Then we had that weird thing in the Carly Gregg case where they tried to dress her up like a 1600 nun/Catholic schoolgirl/emo punk.
That was really disconcerting as a person who survived Catholic schools. I was like, I had that jumper and I remember why. If your chest's cheerily blessed, those jumpers do not look great.
No, but it's the defense who dresses her because she's in prison. She doesn't have any other clothes than her orange clothes, and I bet you she didn't own a suit jacket. She probably owned a promotional T-shirt from what was it, Tropicana? What was that suntan from the 90s with the Swedish bikini team?
Was it like little Hawaiian Tropic?
Yeah, Hawaiian Tropic.
I was thinking Tropic Thunder, and I knew it was wrong. So I was like,
and a little too washed, a little holy, but and by that I'm not meaning the big guy and with holes in it. That's the clothes she wore. So they are trying to dress her to present in a way so the jury will see her as something different. Everyone remembers Karen Reed when what she was wearing, always business cash in court, because we are all biased people. We all judge within the first 5 seconds we meet a person, and you will have a very hard time to get a second chance. So the first impression is very important. That's why they don't put people in prison garbs, because you will see them as a prisoner. Therefore, you would probably be prejudiced against him. She doesn't. I bet you she loves being dressed like this because she feels important. But it is the defense who dresses her up. It's not her choice to look like a lawyer. It's the defense who try to make her look halfway competent.
And I'm sure that the defense has gotten used to Sarah's personality. Sarah wants to be an active part of her defense. So I'm sure that, you know, he would just, they want her to feel like she's doing something, and she's not the type that would Johnny Depp it and, you know, color a coloring book or something.
No.
So
no, she's writing what he should have done correctly. And, they will not be sequestering the jury on this one.
She has many opinions, and she's going to be heard. That's Sarah for you.
Romanis et domus. Which means, Jamie, you are our resident Latin expert.
Stupido.
No, this is Latin. It's not Spanish.
Well, I'm guessing they're not talking about the Ramones, so my guess is probably wrong.
Haven't you watched Life of Brian? Romans Go Home.
Have not.
I have, but I don't watch it on repeat and remember all the lines.
He's writing and they stop him and say, "What's that?" And because it's impossible to do grammar correctly in Latin, they are correcting him. So it goes from Romos et domus or something like that. And then, no, it's a verb and it's a noun. And so he's forced to write 100 times all over the palace. Romans go home. When he finishes in the morning, he's caught by a Roman patrol, another Roman patrol. It was a Roman patrol who forced him to write it correctly to start with. It's a great movie. You should watch it. It's where I get all of my biblical history from. It covers pages 45 to 78 in the Bible.
Nice.
She tried acting like one, and it didn't work out too well. Well, she's doing better than her lawyers.
Yeah, I mean, she cited case law.
Puddletown, I love you today and tomorrow as well.
Oh.
Actually, the female attorney for Carly Gregg explained the clothing on Melanie's channel. Carly had to wear a protective bulletproof vest leaving jail in court and returning to jail. Yes, but you can cover it up. Because we were talking about, you could see the vest under her shirt, but it was just such a weird look. And I know I get called a misogynist whenever I comment on women's clothing, but I think what they've chosen for Sarah is a good look for a female defendant. You look like you work at a bank.
Yeah. And it's not so flashy as to grab attention. It's definitely neutrals. I hope they don't bring the gangrene shirt back in because teal is not her color.
Hey, Christine. How are you doing? They've dressed her like Ilse Koch, who made human... I'm not going to read that one. There was a series called Ilse, the she-wolf of the SS. It was a kind of a BDSM light. Don't watch it. It's not good. Don't ask me why I know. Zach, weren't you leaving? He's not the Messiah. He's a very naughty boy. I'm not going to sit on the sideline when the rest of my life is at stake. Well, she's going to sit in the middle. Rogue, Vortex, go get some sleep. It's a long 15 minutes, isn't it? No, it's actually only 50 minutes and 30 seconds. Yeah, but couldn't you get... Would it be inappropriate to put a girl like her in a hoodie in court or like a sweatshirt? A little...
You could have gotten a larger cardigan that I think would have... But I think because of people thinking of those as parochial school or, religious school uniforms. It was oddly juxtaposed. It was an odd juxtaposition to a girl who, laid in wait, knew where cameras were, and then lured someone else to the scene. It really was. They did this in the oh gosh, it's a famous Indiana case, and if I could remember the name, but there were a group of girls who unalived another girl, and they dressed all of these defendants like little schoolgirls, and it still didn't fly. It just, it doesn't look good. It doesn't. You can put all the Laura Ashley on Sarah Boone. She's still going to be Sarah Boone.
Did you see pictures from yesterday? She was very open in her shirt area. She did have a top under, but she was. I know I make fun of Caitlyn and say bring back the boob window on Friday Night Live, but she was. I'm just saying, if she wasn't as flat-chested as a 14-year-old boy, she would have been showing cleavage.
It was weird how she had bloused the shirt. It was very puffy, very loose, and then it was just a weird look.
And if she didn't have a shirt on, it would be something like this, which is highly inappropriate in court, I would think.
You would think.
It's the same. We talk about this sometimes. If it's a female attorney or a prosecutor, if they, some of them are very pretty ladies. And if they don't put anything under their, of course you can have what do you call it, a cut or whatever it's called, but then have something under. We saw that with the one in the Corey Richards case. To the one who's still upholding the strike against my channel, Sinclair Group. But because she always had a nice shirt under, and then you can allude to a little bit of oh my, but it just looks weird when you have a button-down shirt that's open and it just looks like you really wanted to show off. And we know from Sarah's inmate records that she liked the tight-fitting clothes.
Yeah, it wasn't a weird kind of thing yesterday, and I don't know where on the seasonal chart she lands, for the Mary Kay, like, are you an autumn, are you a spring, are you a banshee? I don't know, but she definitely needs to not wear teal anymore because it's my favorite color and I don't want her wearing it.
Thank you, Kristen Markusen, who's also half Scandinavian.
We're back on the record. 2020 CF 2603, State of Florida versus Sarah Boone. State.
Dave Kester on behalf of the state. William J. for the state.
Defense.
Well, if you had legs like
Ms. Boone is still seated at counsel's table wearing the same gray suit and white blouse from this morning. Can y'all approach?
Yeah. Let's what's going on?
Oh, was that her fan? Was she like, hi, bestie, love you? Send you a letter
it's
soon.
Not Brandy, because Brandy is ready for the Tellis trial. If this ends soon, I'll ship you all over to Brandy because she's been away for a while and she's doing the Tellis case. And so when I ship you over there, remember to show her some muffins because everyone needs muffins. I'd rather see Sarah in business type outfit than Ashley Benefield, so obviously styled to look like a soul and spirit beaten down. Poor little wife, even though she looked fine. Well, yeah, that's what I said, and then I was called a misogynist because I said I don't like the way they dress her to look like she's 18 years old. And I don't know what's misogynist about that. It's a statement about, but apparently you can't say anything these days, and I am a misogynist.
Well, that's why you brought me on. I don't
Yeah,
like turtlenecks. For me, just personally, I do one of these things every time I have a turtleneck on. It feels like the cone of shame. I'm like, no, I won't even scratch at my stitches. I promise. Don't put me in a turtleneck.
I remember when we had to wear those, and then you had like a polo over because it was real cool to have.
Oh God, Baker.
Baker was tight rolling
Did
his
you
pants. He had
wear a
the
gold chain too around your turtleneck?
I didn't have the rock gold chain, no.
Oh man, that
Then you
would've
had
been
the like in the mid 2000s, you had the grandpa tee and a polo on top of it. It was such a bad. Why have a short arm sleeve and then a long arm underneath? And I hate I can't stand anything. As you can see, I have quite the meaty forearm. I don't like having shirts on. When I had like a hoodie on, I'll pull them up because I just hate it. I should have been in Miami Vice sporting a sport coat pulled up like Don Johnson. That's his name. And Vince Clotho gifted a membership for Michelle Smith out of Australia. Thank you so much, Vince Clotho. I just ate a pistachio muffin. I like pistachio ice cream.
Me too. Maybe they're going to have Sarah just whittle down those files or those, medical records for them. Like here's a activity.
Here's a Sharpie. Can you fix it?
Mm-hmm.
I hate everything that goes up high because if you have a little bit of I don't shave. I have like a Phillips one blade. It's like an electric, but not really. It's not it doesn't go as hard on the skin. But so you need to shave way more than you normally do. But when it gets stuck in a shirt, it's so annoying. I hate it. It's because you're a white Scandinavian man. Well, I'm a white Scandinavian misogynist. And I apparently am very misogynistic.
I just wanted someone to go back there and pull the back of her jacket down. Just yank it.
But everyone needs to learn. Oh, I just yanked my monitors. Everyone needs to learn that little trick before you sit down. Just pull it down. It'll ride up. Everything will look fine when you sit down. Baker, the bad biker. I have ridden on one motorbike in my entire life. I've never seen the allure because I know if I had a motorbike, I would kill myself within 5 minutes. How did the motion go? A little bit column A, a little bit column B. The defense didn't really seem like they knew what they were talking about. My favorite is vanilla with Reese's Pieces. I'm not a fan of. Don't forget grifter. I am a misogynistic grifter. How do we get trial bingo cards?
All right, court's going to step out for 1 second, and then you can email that exhibit list to Madam Clerk, and then we can go from there. Thank you.
What's going on?
Are they going to show voir dire?
No, they still haven't done what they were supposed to do.
Oh, they're trying to find their amended exhibits list.
Yeah.
And Owens is like, oh, it's in my draft email. Dang it. I knew I was supposed to do something yesterday.
Not with all those crazy tattoos. We can cast you in a biker show. Oh, I could be in a biker show. I could be that guy sitting by the door saying, hey, son, didn't you know it shouldn't be a place you should hang out? Do you know what happens in here? We have a 2-drink minimum, and if you touch the girls, I'll touch you, and not in the same way.
Or in the same way. I mean,
yeah.
Yeah. If you pay 10 times the price, frosted rainbows fall. For trial bingo, I will share the link in chat before opening statements. Jemima, will you do it on both my channel and Mo's channel so everyone can play along? Because everyone, remember, we are dual streaming with the wonderful Mo. Mo is a good old friend, and she is very close to 4,000 subscribers.
Woo!
It would be really, really fun if we, doing this trial, could get her over that bump. Mo is primarily doing shorter streams. She's not always doing live trial coverage like this, but she has a very good morning segment where she doesn't do the news the boring way where she sits there and say, just in Kuala Lumpur, a female by the name Jamie from the Ohio State University has been fighting a volcano. No, she takes the funnier parts, and then sometimes she brings in Mr. Chippy. She also do nightly news if her legs can't keep up with her. Yes. We all have our little trouble, but you will not find a funnier person on this planet. She peppers it with wigs, Uranus, and weird stuff she buys on Temu that her husband can't learn about. So everyone, while we are waiting here and just sitting here thinking, is dust really settling on my brain right now because I have to wait for this long?
Oh,
there's a link in the top of the chat.
The project I picked for this trial. Note to self. Look at measurements before one buys things, because this is a honkin' huge giant diamond painting thing. And diamond painting is good if you have OCD or endeavor to have it one day, because you have to put these little buggers on exactly the right way on this flypaper glue. And it does calm you, and you cannot snack while doing it. So it's part of my being mindful and not snacking thing. But oh my gosh, it's a whole lot.
They're like little diamond, like little
diamonds. They're like little diamond dotty things, and it's got a glue on the background. So you put because I just wanted to see if I was able to do it, because I was like, oh, this is going to take me 800 years.
Mm-hmm. That's kind of cool.
And it's, let me see. I clipped it up so I could not. It is a chick. It's not Sailor Moon. I did look, but it's a semi chick with all the, Art Deco stuff. Look, Pain Me might have bought these when Pain Me doesn't look at measurements for anything. So.
Oh, that's going to be a lot of work. So that's going to last you a while. That'll be fun.
Yes.
And Crafts with Nightingale has a diamond painting channel.
Oh, cool. I will go to that to look for all the tippy tips, because I realized I have shaky hands, and this might not be the greatest, art project I've ever gotten.
I'm just saying, all of you guys who are thinking right now, is she going to bejazzle a female? Yes, she is. Yes. And get your heads out of the gutter. Don't they already have over 40 potential jurors? Yes. They need 6 and judge want 8 alternates. How many more before they can see the jury? That's why they're having the voir dire of the jury members, because they have given them the overall questions. I don't know if you call it that in English, where you're saying, have you known this case? Do you know Sarah Boone? Now they are going to go and read they probably have a questionnaire filled out, and they have read that and said, you state that you really love hide and seek. Have you ever hid it in a suitcase? And then they're going to whittle it down one more time. We have enough potential jurors, possibly, that we will be seating a jury today, tomorrow, and the case should be starting tomorrow at around noon. I have set it, cross my fingers, for 1 o'clock tomorrow for opening statements. That's what we are hoping for. But one is hope, another is reality. In this case, Seems like it's going to be a case of a lot of this. And that's why it's lovely to have Mo on, who you should follow the link over and subscribe to her channel, because Mo is one of the best talkers of the YouTubes. Just like me, she has too little filter and too much mouth. And that's really good when you have to fill a lot of time. We can take it anywhere, like bedazzling women.
Well,
and
you
I
know,
didn't
it
say
was,
bedazzle. I didn't say bedazzle, so don't go there, Jamie.
yeah, well, you know, Mr. Mo has to allow me some, you know, craft money, because otherwise I'd be out on the streets slinging LuLaRoe, trying to get you to, you know, join my pampered chef parties. It keeps me off the street and out of trouble.
Yeah, we don't want any of that.
And
Most friends force that pampered chef down your throat.
No, those are reverse hostage situations, because you're like, oh, it's my friend. So you're over there like looking for the cheapest thing that can not, it is not bedazzled with like flowers. LuLaRoe, there are other patterns other than flowers. Have you thought about curse words? Because I'd buy the hell out of some curse word shirts.
TJ White, the link is on top of the. I can close my. I'll close my my poll. Then you can see it. It's on the top of my chat, and I asked, would Sarah have more luck as pro se? 42% says no. 34% says dogs playing games, and 22% says yes. Yes, you can also check out my links for you. Thank you, Wolfie. Does anyone know if Jorge's family has been to court? No idea, because I've only seen small little clips of it, and it doesn't seem like there have been that many people in there. I think the defense is trying to make opening statements delayed until Monday. I think they might be doing that, but the judge won't let them. He has said we are going with this trial. It's set for 3 weeks, and he wanted it gone. It's kind of like the Quentin Nixon trial. We're also following that.
Oh yeah, that's still going on, isn't it? God.
It was set for 2.5 days. It's been going on for 6 days, and it's delayed until the 29th. So,
oh my gosh.
in the best of both worlds, which is a Hannah Montana song, this case ends on the 25th, and we'll be ready for Quentin. I prefer White Ceiling Fan over the Great Seal of Florida. Just saying. Yeah, and who's that chick, and why is she watching that boat? Thank you so much, T-Rex.
Because her Timu order is on there, and she wants to make sure she gets it before porch.
All right, we're back on the record.
Exactly.
2020 CF
Hey,
2603, State of Florida versus Sarah Boone. State, let me get appearances.
William J. for the state.
Defense. Thank you. Ms. Boone is still seated at counsel's table with the same clothing from this morning. All right, I've been provided by.
Oh, the OG gangster Granny got 5 years. She's the one who fell for an online dating scam and then robbed the credit union. Do I think it'll take more or less time than 3 weeks? Give me 2 days of the state going through their lists, because they have 50 witnesses. If it's just going, it'll be a maximum 3 weeks. The problem is if it's like the prosecutor in the Quentin Nixon case, it'll take forever.
By Madam Clerk, defendant's 5th amended reciprocal discovery exhibit list. I haven't had the opportunity to review it yet, but it is in my hands. Let's start with the defendant's objections to state's digital exhibits. I'll turn it over to you, Mr. Owens.
Judge, and I did want to say that the notice of provision of defendant's 5th amendment exhibit list was e-filed on October 3rd. The 5th exhibit list was emailed to the state on October 3rd.
Correct. But the same problem I have is it's just the notice of provision. I don't know what any of the substance was. All right, you may proceed, sir. Okay, go ahead.
And Judge, this was a little bit of a new procedure because what I did was review the images and these, as in the motion, we object to all the cell phone photo evidence. The state intends to introduce a trial.
Why does he sound like he's already given up?
Have you been around Sarah Baker?
Yeah.
He knows his address. He can't leave.
Yeah, and then just pull it down the mic 2 centimeters.
As to,
Can't do it.
I'm not going to know until I hear evidence or see when they're trying to introduce it, if it's relevant or not at that time. Something might make something relevant at a certain time, or it might not make it relevant. So there.
Is Schrodinger's evidence?
Foundational stuff.
It could be or could
because
be.
The images, as I've seen it, I don't have dates. So I don't know when it was taken in relation to the February 23rd, 2020 date, which is the date of the offense. And so I'm at a loss for that. So I don't know if it's 2 years before, does that make it relevant? If it's 3 years before, I don't know. So that's going to be, if the foundation is laid, that's my problem with these photograph exhibits, is I don't know until I hear who's trying to put it in, how's it identified, and if the proper foundation is made to make it relevant. Okay.
Response?
He comes up with a laptop citing cases. This guy's like, I'll know evidence when I see it. It's like prawn.
Yeah. Yeah. We had a minister of well, she was taking care of sports too, and she said football is kind of like smacks. It's funnier when you participate. It's the same thing. I don't know why that just popped into my head when you said prawn.
It's going to be considered a separate hearing for the record. So should this be D or should it be A?
Everything was, when I called what was being heard today, it was all in the same hearing. So I believe it should be pre-marked as D.
What I'm having Madam Clerk mark as D for identification for purposes of this hearing is what has been provided to the defense as the very narrowed down portion of the phone extraction carve out. What it has is what, and we were even so specific that we labeled one part of the PDF case in chief pages, of which there are 59. We labeled rebuttal pages, of which there are 108. Attachments that go to the case in chief timeline. Count up as 80 photographs and videos. Attachments and rebuttal. Count up as 147 photographs and videos. There is metadata that comes with all those files. So there is a date stamp and timestamp on each of those files. For instance, 12/25/2019, 1:10 p.m. Another one might be 10/26/2019, 6:06 p.m. They all have file names. Providing context.
I love this guy. He just slaps him with everything is in order, your judgeship. We can't help it that this guy's too stupid to look into the metadata.
He's like, you mad? You're mad, man. How does one look at a metadata? I mean, I'd be clueless, but
it's kind of a thing that you should know, like 10 years ago when they started putting everything in digital form via Cellbrite. You can read it in Cellbrite. In Cellbrite, there's what's the subject of this line.
Oh, yeah.
Then it gives you the date in your time and UTC code. And then it tells you who called, who received, and how long did it last. Or this picture was taken at this, if you have your GPS thing location on, it'll give you the GPS code for where the picture is taken. I know that because some idiots really liked filming them dismantling cars with their GPS on, so we knew it was that place. Defense speaking so slow. Why? He's grasping at straws, Iris. Grasping.
Would be the PDF outlook or PDF outline of the phone extraction, of which the state will now move into evidence so that the court consider this as states 4 for the purposes of these hearings.
Any objection to what was pre-marked as D? That will received without objection to states 4.
So
hey,
James, to give the court an example.
Yeah, and the next time she was in court, she did state that now she had opened all of it and had to say
on page
yes.
49 of 59 of the PDF labeled case in chief, entry 31107 in this PDF from the phone extraction is labeled videos. 2/23/2020, 11:12 p.m. 45 seconds, UTC -5, which means corrected to Eastern Standard Time for that time of year. And it's image_1062.mov. So that sort of information is going to be there for the majority of these files. The ones that end up getting recovered from unallocated deleted space are sometimes not going to be there. But there will be contextual clues as to their relevance. The court will be able to see that. So for instance, that image is the 2-minute infamous video of Mr. Torres being in the suitcase that started at 11:12 p.m. 45 seconds on February 23rd. So there is context that can be used both on the metadata that's in the file when you list these files by details instead of by icon, and then within the timeline. And what we have carved out is the case in chief timeline.
We had the wrong outlet or outlook.
As a
It
conversation
was on portrait, not landscape.
that begins on Christmas of 2019, and it starts with Mo, presumably the decedent's brother, having a conversation with Sarah.
I was nowhere near
owner of the
Sarah.
phone, and it culminates
Unless
in
I
hide and
blocked that
seek,
out.
I shall. That's the context of that conversation on December 25th. Then it goes down to conversation that's going on January 12th into the 13th of January of 2020. Culminates in a text from the owner of the phone saying, "And bless you and all of you too, I'll get capitals rid of him." So that's the context of those portions of our case in chief PDF. And then there's just the timeline that starts with February 23rd, 2020 at 8:35 in the morning and goes through the entire day to give context of what is going on with her on the phone. Is she using it? When is she presumably awake? That's the context of that file. The rebuttal file, which is, again, 108 pages. It starts, and it basically involves with conversations with or about the decedent, conversations with his family, which I anticipate the defendant is going to testify she was terrified of, and there were problems with all the time. It's going to give some context to those things. It mentions when they became a relationship on Facebook of March 8th of 2018 to give context as to when perhaps this relationship started or not. And then there's a timeline that starts from May 21st, 2019.
They became Facebook official.
That is filled with conversations.
It's
about
not Dylan.
His
with
letter
Facebook.
jacket.
The decedent. At that point in time, he had his own phone, and then at some point he doesn't. And the discussions and the arguments between him and the family with the defendant. And then the images that are associated in the folders, like case in chief and rebuttal, are the ones that are associated in these time frames. I have cleared out the vast majority of them. The vast majority of them were just icons and things that belong to games and nonsense. I cleared out all the photographs of Mr. and Mrs. Boone's child, any of the child's friends. There was no need for any of the pictures of the children. It's mostly photographs of the decedent and the defendant, but there's also just pictures of art and them going out because it gives context. You know, if she's in the middle of an argument, for instance, with the family, you know, one might expect there to be pictures of injuries. Instead, there's pictures of art. So we did our best to select which photographs and videos were pertinent within these timeframes. We did our best to narrow it down to what timeframes we set. We believe will give a good rebuttal picture after she testifies about his family and her relationship with him. So that's where we're at. So as far as like the relevancy, the general relevancy objection that was made, there was no specificity as to what particular entries in the PDFs are objectionable for any particular reason. We believe that everything is relevant. Again, we are submitting it for the court's review. I know that we're on the third day of jury selection, which will apparently resume in 81 minutes. If there's an authenticity issue, because one of their objections was relevancy, foundation, unknown origin date, hearsay, and Crawford issues. I'm submitting for the court, if I can approach the court. Gilbert versus State, 324 Southern 3rd, 598 from the 2nd District Court of Appeal, decided in 2021. Lamb versus State, 246 Southern 3rd, 400 from the 4th District Court of Appeal, decided in 2018. Gale, G-A-Y-L-E.
Nothing, Julie. They have been, they're just talking technicalities. Iced lemon pound cake.
Low bar for authenticity.
That sounds good.
As Professor Earhart from Florida State University
illegal to mention
tell
cake
us,
on my
authenticity is a very low bar for the court. It is generally considered a matter of weight for the trier of fact. And with this digital evidence, it can be established and authenticated in a variety of ways. What the state expects the evidence is going to be is that the defendant's phone was taken from her home by law enforcement, as we know from the motion to suppress, and it was provided to a digital forensic examiner who was able to use the defendant's passcode to unlock it and perform a digital extraction. So that should clear up most of the authenticity issues as to who the owner of the phone is. The state readily concedes and has provided context by using extra pages of conversations that at some point the decedent no longer had his own phone and was using Ms. Boone's phone from time to time. And in fact, that is part of her allegations about pornography and contacting other women. But I believe the context of those conversations makes it clear who is using the phone and who is not using the phone. So we believe that there is no foundation issue. We believe, based on the defense they are raising, that there is relevancy. We have split it up to the case in chief and the rebuttal. We are specifically only entering the two incriminating statements in the context of those incriminating statements about hide and seek and getting rid of him, plus the timeline of the date of the offense. Then the rebuttal, we have carved it out as best we could to present a picture of the conversations and the tone, as much as tone can be.
Oh, she's writing a letter to the manager?
And how the relationship was with the family and who.
Dear sir, who would make concern.
As far as hearsay and Crawford
my
issues,
lawyers,
I am unclear if they are talking about just in general the digital forensic extraction
Please
report
let me
itself.
take
One of the
over
cases
again.
I gave to you makes it clear
I
that
will
machines
take
are not humans. They do not get subjected to Justice
can't with
Scalia's
you.
version of the
Ooh,
confrontation
those
clause
are
that he
some
outlined
hate
in Crawford
eyes.
versus Washington in 2004. What he also talked about, though, and what has had some discussion since the Crawford decision was what's hearsay versus testimonial hearsay. Obviously, there's no testimonial hearsay in these phone extractions. There's no implication that any of these statements made by any of the participants in the text conversations were doing so with an eye towards litigation or prosecution. So it's the state's position, number one, that the extraction itself and all the data that is coming from it is not hearsay and it's not testimonial hearsay, much less. And the conversations that are going on with the other people.
Dear diary, I missed the bush. She missed the Dr.
This has to. What is going on? He's like, we don't know where the evidence came from. They could have gotten this from like Google Images. And he's like, no, there's this thing called metadata. We even broke it down because we realized you guys seem to have issues with, well, lawyer stuff.
Yeah.
That's a thumbnail look right there, Baker. I would screen grab that. Well, I would screen grab the angry writing.
Yeah, and the bitchy side eyes.
Yeah.
The statements that other people are making back to the defendant in the carve-out that we've provided aren't being offered for the truth of the matter asserted. There is no hearsay issue. It is to provide the context of the things that the defendant is saying. I'm going to go bond Jorge out. I'm going to go to the public defender's office and get this taken care of, or screaming at his family, so on and so forth. Demanding immediate responses when somebody's cutting hair and keeps on telling her repeatedly, I can't respond to you. I'm working. So those sorts of things, it's the state's position, aren't being offered for the truth of the matter asserted. As far as the unknown origin date, I think it's
what
pretty
about
clear
the B
from
for
the
the matter asserted
timeline that there is a date and timestamp to every single entry from this
We're
phone
laying
extraction,
foundation
and
of
that corroborates
beatitude.
with the images. Most of the images, some were from unallocated space, but it corroborates the metadata for these images. So we're asking for that their motion or their objection to be denied preliminarily. Obviously, we have to lay the predicate properly at
Owens
trial.
is so scared
Now the
he's
court
going to
has
be
a
alone
copy,
with
and
Sarah.
hopefully we can get advice from the court if the court is believing that there are sustainable objections before we swear in the jury, so that the state can pull any photographs or videos, or we can have at least a discussion about those
hasn't had her
specifics.
snack yet.
And then after discussing those specifics, the state can pull those out before burning and
Quick, Owens, throw her a peppermint. It
jury.
worked for Mr.
We
Ed.
also have the ability to black out entries in the PDFs. Again, no specific objections were made, so it would be our position that they're waived. There was a generalized objection, but so that we're not doing this when the jury is out. Trial is busy enough, trial is tedious enough to not be conducting discovery and doing redactions during the night.
No, prison said we can't have them do makeup because we can't control because you can lace it with anything. When I read the P. Diddy new lawsuits this morning, apparently he had lubricants laced with GHB. Just a little side note, if you need something to watch later, you can go back and watch that stream. Not for kids.
In mornings.
Yeah.
Thank you. Response.
So is this a laughing chat trial with no real defense? Well, the defense is that she intentionally deleted him because she's claiming battered spouse self-defense by accident. I don't know how that works, Rubia. You're a lawyer. Maybe you can figure it out. Her lawyers doesn't seem to know either. And none of them seems to know what case law is or why anyone would mention that anytime soon. It's just stupidity.
Judge, I think this procedure calls for a lot of speculation as to the defense part, as to what these photos, examples of the photographs, what's the use of this photograph? There's a piece of art on the wall. I don't know how that's relevant to the case. So without knowing how it's relevant and what their theory is of it being relevant,
You're wrong, and they haven't told me their case.
I don't think this is relevant.
What's your response to the lack of specificity? That these are just boilerplate objections to all photographs.
I like him.
All
I really like him.
Yes, well, they're not to all photographs from all videos. There are things that we list.
It is an objection to all cell phone photo evidence the state intends to introduce. Correct. It is objections to all cell phone video evidence the state intends to introduce.
Because at this point in time, Judge, I can't tell you what the independent objection would be. I don't know how it fits into their theory of the case. That's cause for me to speculate how it fits into their theory of the case. How can I do that? If they show you a picture, like a picture of artwork, all right, I don't know how that's relevant to this case, or a conversation that takes place between two other people. At the time, I don't know how it's relevant to the case. So what am I supposed to say? No objection to it? And then am I later barred from objecting to it?
No,
I don't think it fits, so they hadn't laid the foundation to get it in. It's putting the cart before the horse.
No, that pertains to the rebuttal evidence.
No.
What about the evidence that was outlined that the state intends on using in its case in chief?
That's it, Judge. How do I know they are going to be able to lay the proper foundation for that evidence? How do I know?
Because they have the metadata.
That's the thing. Because
I
think the procedure goes like this.
Lawyers?
Yeah, I could be wrong, but I don't think so.
You
the
are
procedure
wrong.
goes like this. The state has a piece of evidence. They have that evidence identified to someone. All right. They get it marked as an exhibit. Okay. At a certain point in time, the state asks if we'd like to introduce exhibit number 1 into evidence. Defense, either objection or no objection at that time. I've heard the witness who've identified it. I know what it is at that time, and I have some relationship to it at that time to make the proper objection. Just getting a picture now, and I'm supposed to say, no objection. I don't know what they're using it for. Guess what, Judge? The videos of the suitcase, we didn't object to those. Do you know why? It was clear. I know when it was, and I know the purpose of using it. But when you have animate objects on the wall, or pictures of individuals, and in this case, there's
but what I'm reading,
right?
it sounds like you're objecting to those. All cell phone video evidence that the state intends to introduce.
Correct.
Sounds like it covers the suitcase video to me. All means all.
The suitcase video is listed in in the things that we don't object to.
I don't know that. I have image underscore 0954. I don't know what that is. Image underscore 0980. I don't know what that is.
Okay.
I'm just looking at the words on the paper.
How does it need to be done, Judge?
Well, what the state is asking for is a preliminary ruling on these objections.
Is he telling the judge that you should just rule on this? You don't need to know what you're ruling on?
Yeah, he's like, I don't need to clearly outline what I need. That's mean, and that expects too much from me. I got on here. He didn't start with the patented, as you know, Your Honor, we got this case blah 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 days ago. I mean,
and we really haven't had the time to. He just said, you don't need to.
Jedi Jess, I think you need to just voice. I'll just read your. Are you daggone kidding me? Did you ask the judge how to do your job?
This is like a pro se asking, how do you do that? Well, I can't tell you. That's why you have a lawyer. These are lawyers saying, hey, judge, what's this? Evidence? Have we heard about that before? Is that covered in law school?
Also, they don't want to give away their case because it's all precious and such. But we need to know exactly why the state is bringing in this god-awful painting of Pooh Bear.
Yeah, because that would explain his drinking.
Yeah.
How do you have a preliminary ruling on an objection when the foundation or anything has not been laid in court for evidence being admitted?
State conceded they need to lay the appropriate foundation.
Well,
part of their argument.
Okay.
So I'm not going to address foundation. If they're able to establish it is what it purports to be under the case law, under 90.90.
This is what you do in every freaking trial. You show the evidence to someone and say, is this, like Trooper Guarino, you ask him, is this the Cellbrite video you downloaded from the defendant's phone? And he'll say, yes, that's laying foundation for the video. At what time was that video recorded according to the metadata on the 23rd of February? Have they never heard about laying foundation? I don't think they're criminal lawyers. I don't think they have ever had a case in front of a jury before. I think they are clearly deal lawyers.
It's not speculation. Again, you ask the questions, you lay the foundation, and then they can bring it up. The state is not obligated to give you their entire case.
They were just arguing before the break, we don't need to give the state our case. They want our case.
Yeah. I'm going to need to go to therapy after this.
You ask, you were the first officer at the scene. Yes. Did you wear a body cam? Yes. Have you reviewed that video? Yes. Is it a true and accurate depiction of the conversation you had with Sarah Boone? Yes. Let's play the video because that's foundation.
Oh, one and everything else. I mean, he's right. It's a low bar for what admissibility is.
And I have no problem with that.
Okay.
I have no problem with that part, Judge. The thing that I'm saying is, I want to make sure, because I didn't object to something on here, it waives my right to object to it later.
Okay.
That's what this sounds like to me. It sounds like this is a situation, well, Mr. Henderson, you didn't object to this on the state's list. of exhibits. You did not object to it. You can't object to it now. I don't think that's fundamentally correct. So I don't know what part I'm missing.
Anything else, sir?
Well, yes, Judge, I would like, because I know it's a different jurisdiction. People do things differently, okay? 30 years, I've never had to do this in a criminal case, okay?
Part of the reason the court issued the order back in August is at that point in time, Ms. Boone was representing herself pro se. And we need to establish deadlines to prevent any ambush or last minute issues. Then you all parachuted in on August the 30th.
Yes.
There was no order. There was no request to vacate any of those deadlines. So those deadlines were still in full force and effect.
Lay the hammer down.
The reason behind that was because Ms. Boone at that time was representing herself pro se, and to avoid issues at trial, the court had set a schedule for when certain objections needed to be provided. And I understand your position. I don't want to be in a position where I'm deemed to have waived anything. I get it. But the state's proffer seems to have established some level of relevancy for these things. And as we well know, the bar for relevancy is very, very low. As the foundation, I agree with you. And the state concedes that point. They need to establish the appropriate foundation. And if they're able to do that, I'm not foreclosing you for making objections, but as of this point in time, your objections are preserved for the purposes of trial. You can raise them, certainly. But at this point in time, based on the state's proffer of what they intend to use and why they intend to use it, I'm going to find that it's relevant and not repetitive.
Judge, at this point in time, as a pretrial ruling that doesn't waive my right to object to something as they're trying to admit it based on relevancy, foundation, or any of those things, then I don't have a problem with that. What my concern was, the way this looked like to me, if I didn't make an objection to it at this time for this, I am waiving it at trial.
I understand. Any clarifications or questions with regard to the court's ruling?
I believe we're trying to treat this like a video interview redaction issue. Like, it takes time to go back and pull out pictures and pull out videos or black out lines or.
Ralphie, they are even worse defense attorneys than Sarah Boone was. They have no idea how anything works. And so far, what we have gotten is Schrodinger's digital evidence. It could be evidence, it could be not evidence. Hey, Brandy, I was just saying earlier when we thought this was about to end that we were going to raid you, but thank you for the raid. And, oh, I can't wait to hear about your experience in court, because these defense lawyers, oh my God, as the kids say, they are the worstest.
This is, it sounds like he doesn't want to, again, I don't think jurisdictions are that different in how procedurally things go, but you can object during the case to evidence.
Yeah, he doesn't understand that when they are, that's why they say every time, show the pictures to the defense or the state, and they can go through it and say, Your Honor, I object. They can object to everything at any time, but he thinks if it's let in now, it's unobjectable. That's not how it works. Again, I'm a baker. Jamie's a candlestick maker. And Mo is a housewife. And I think we have a better grasp of the law than these people does. How can you tell metadata? It's in the extraction file.
Sarah Boone, call me. I will represent you, but I will be there in a different wig every day, and I will be drinking hella Diet Dr. Peppers right in front of you. Like the Theodore Edgecombe case, I will have 3 cans lined up on oh gosh, it's not called the pit stop, but the warm-up batters box. And then I will have more in a cooler by me, and none for you. And I will just be eating peppermints. I am that petty, but I will probably do a better job, Sarah.
And Brandy, I can't wait to hear how, tell us about her smell.
Oh, and Brandy, brows of justice. You gave me an idea. But we love our judge and brows of justice for verdict day and possibly other days, because this case is going to kill me.
It's going to be a long trial.
Remove pages. That's all we're trying to do, is do that today. I don't know what the defense expects to be different at trial, what more information they're going to learn from the digital evidence. I mean, the foundation for this evidence is going to be the law enforcement officer that took the phone that is pictured in the CSI photos out of Miss Boone's apartment. It's right on the nightstand next to the suitcase. And then that person's going to have to testify, well, I gave it to Junella Wadden. And then Junella Wadden is going to come in and bring the phone with her and say, this is the phone that I plugged into my Magic Cellbrite software or whatever she used on that particular day. And this is how Cellbrite works. This is my educational background, blobbity blobbity with this software. And I pulled this extraction out. Mr. J sent me this carve out of this extraction before trial. In fact, she picked it up yesterday. And I believe, I'm going to testify that this is part of the larger carve out. This is from her phone. That's going to be the foundation. The rest of these things are things that we should be able to have an intelligent discussion about today with specificity about this line of text isn't okay. This particular photograph's not okay for this reason. That's what we were hoping for.
Okay. Have you reviewed what it is that the state intends on eliciting in this exhibit?
Yes, Judge. This is the things that I reviewed. I sat down last night and went through every one of them preparing for this hearing. What we did not, or what we failed to do because of the time restraint for the ones that we didn't list a number and I didn't give detail as to like IMG 0954, what it represents. My concern is this, because I don't have a problem with this or with the state's.
It's probably because you filed a motion to exclude it. It's probably a good thing to know what EMG 0504 is. Just so you can say why you don't want it in the trial, instead of just saying every picture and every video must be taken out. I don't know. I'm not a lawyer. I only laugh at them online.
Evidence at this time, as long as it's not a bar, that when we come into court and I feel something is not relevant at that time, or they go to admit it and I say objection relevancy or objection foundation, then I'm not barred at that time. I don't know any rule that would bar me at that time.
But
then why would you think it would happen here?
I'm going to overrule your objections for the reasons that I previously identified. You can raise your objections at trial if you deem necessary.
Yeah.
Based on the state's proffer, I'm going to find that the different categories of documents that he's identified as reflected in Exhibit 4 are relevant. They are not repetitive. They're not cumulative. And so long as they can establish the appropriate foundation and based on counsel's proffer, seems like they might be able to do so.
He's hiding it well.
Any questions, sir?
Now, I just want to add something for the record.
Yes, sir.
The state doing its proffer said there were no photos of the child. That's not correct. There are photos of the child.
That are being sought into evidence?
Yes, Your Honor.
State? Response, if any?
Just that picture of him in the suitcase, but I mean, why would we put that in?
Yeah. No, this is Molly, my vacation doggo. She's a little upset because it's our walking time. So she wants to go out and have a pee. Yeah. It could be, but let's speed it up and find out what's happening.
Amazing. The state knows where all of the evidence is, and it's just looking it up.
Folders. I don't have any independent recollection if I tied it up more than when I gave them what I believe the exhibit to be a week or two ago, but I don't see any.
Turns out it's just Sarah crayon drawing and put Lucas on it like a little stick figure.
How can you be this bad? We only had 45 days. Samusha.
And okay, I'll be the chick that says it, but that his daughter's skirt is way too short for a courtroom, especially when she sits down.
Yeah, that's a lot of thigh in that skirt.
I hope she has some squirts on under that too. Otherwise, we're going to have some basic instinct. Maybe that's how she's going to win emotions. Your Honor, uncross leg, recross leg. Would you like to rethink your objection to our motion?
This skirt. This is this guy's daughter.
I mean, she has great gams, but...
That's a tiny courtroom and skirt. Yes,
Oh, Detective Goodhair is back there. I see her. Come on. Let's just have a palate cleanser.
Over here, behind her.
Okay, I see two images. I couldn't recognize it as a reflection of children in a, I don't know if it's a snow globe in an aquarium or whatnot, but I have no objection to removing those two. I just didn't recognize it as children. I recognize it as a crab.
I haven't seen the picture, so I'm at a loss.
Well, I'm sorry, Judge. Extraordinary file name.
I'm sorry,
but,
we thought it was a crab, not a child.
I'll take care of that issue for you, sir.
That takes care of that issue, Judge. But the point that I'm trying to make with that and why I raised it is that there are going to be certain things that
they haven't ruled anything about the snacks, but she got 2 glasses of water this morning. Ja, du kan spise mig nu, når du er aftensmad.
I'm not going to know. And 2, what is the purpose of it as far
He's
as how is, how is it relevant now? They can make a profit.
Why should I speak English to a Danish dog? You don't go around saying speak Danish to your dogs.
I understand they can make a profit, but their
I
profit
would
is
if I
evidence.
could.
Once it goes up, the witness is in all, and the court has told me that I don't waive my objection, so I understand the court's rule.
You don't.
All right, thank you very much. Anything else with regard to the defendant's objections to state's digital exhibits, Mr. Henderson?
No, Your Honor.
Okay. Moving now to the defendant's 5th amended reciprocal discovery exhibit list and the state's objections to same. There are some for which the state has no objections. Those need not be addressed. It will just be dealing with the objections outlined. It is not lost on the court that it is 12:30. We do have a jury coming in an hour. My court staff does need a lunch break. So how do you want to proceed, Mr. J?
I just want a ruling before we swear in the petite panel.
Okay. Do you have any concerns with proceeding with jury selection this afternoon and the final portion of the court's inquiry as addressed yesterday and turning it over to you without having a ruling on these? And we could address these objections tomorrow morning before we bring in the balance of our panel? Or is that acceptable to the defense? Okay. All right. So then here's what we're going to do. We're going to be in recess till 1:30. We will report to the 23rd floor. I've already advised jury services and court admin that a room is available for us. We will continue jury selection at that time. I will keep you apprised of whether or not we can continue jury selection in 23 tomorrow. As soon as I have that information, I or my judicial assistant will pass it along to you. Assuming we're in 23, we will advise the jurors when they need to return, and we can address all these objections tomorrow. And we'll address those objections either in 23 or in 12 alpha. Anything further from the state?
No, Your Honor.
Anything further from the defense? Okay, we will see you all at 1:30 and 23. Thank you.
Well, this is already turning out to be worse than I thought it would.
Mm-hmm.
Yeah, this is, I'm going to have to go to therapy and show on a doll where in the brain this hurt me. And just about everywhere, Your Honor.
Yeah, I love the Schrodinger's evidence. It could be, it couldn't be, we don't know. It's just maybe. Let's look at this wonderful woman. Oh, watch out, there's a suitcase behind her.
Yeah, but what relevance does that have to the case? I don't know. This is confusing to me.
My cat is bilingual, Korean, English. He just chooses not to listen in either because cat, love you guys covering this. KDP, we love, you also have, Molly is, I think she's a cat because she sleeps all the time and whenever I call her, she runs away. So I think that's kind of the same.
Yeah.
And
Just
right now
about.
she's sitting on my table on the keyboard and it's a little bit in the way, but it's because we need to go out, have our evening pee, and then she needs to have her dinner. Well, Are you sitting on my pen? I used to have a pen. Okay.
He used to have a pen.
Well, she's really fun. She eats my socks. That's so weird.
You only have 2 pair. What are you gonna do? You're gonna have to buy new socks.
Yeah, I have to put on the Swedish ones that I got from Panella.
Uh-oh. That was Molly's plan all along.
Yes.
She is a collaborator with the Swedes.
She's like, yep.
Seems about right.
Uh-huh.
Så, sæt dig ned. It's a her. That's why she's called Molly. No, Melissa, he's not serious. Well, this concludes day almost first of the Sarah Boone trial. It's been a roller coaster of what? Are you sure? You can't be serious. So we can't wait for tomorrow when opening statements hopefully starts at around 1 is where we are betting at. We will be covering it as soon as it goes live. We will be dual streaming this trial. If you're on my channel, please look at the link in the description of the chat and go over and give Mo a little love. We are chasing 4,000 subscribers for Mo. Please go help her out. She is one of the funniest people you will ever meet on the internets, and she have wigs. I don't know if that makes her more or less funny, but she do have them.
More. Because, I mean, other than me and Brandy, who went out and got, you know, fabulous eyebrows? I just love this judge. This judge is like...
Yeah, what do you want me to do? Why? That does make... Have you read the law? I'm thinking...
I mean, if the judge doesn't have a bottle of clearance cognac on his desk and he's like, look, it is 12:05. I'm gonna need to drink all of this.
Somewhere.
He's just on the phone with his wife. Dear, just, you know what? We're going out drinking tonight. Just
get the electrolytes ready. I'll need it tomorrow for court. Yes, Krennic has a fresh haircut. He's looking spiffy. Also, I will have a new haircut tomorrow.
Well, and he did, honestly, he was trying to help the defense, and it's so incredibly irritating to me to see people who are not prepared and waste people's time. And I don't doubt we're going to get another pregnant pause, you know, admonition from a judge, because this defense has no qualms about wasting people's time for dumb motions. And I have a feeling that this other, I don't remember his name, but the speculation lawyer is going to object to everything.
Yeah, just because he couldn't get a motion objecting to everything, so he's just going to say, objection, Your Honor. And I think the judge, I think he has a bit of Borowski in him. It seems like calm water over a deep ground, where when he loses it fast, because he did that with Sarah sometimes. Stop licking the mouse. And it's really annoying when you can just see your marker just going across all 3 screens because she's licking the mouse and moving it. Yeah, vi skal nok komme ud og gå. But we'll be back tomorrow at noon because I have a little dog who needs to go out and do her tinkling and her tangling. I don't know why I say stuff. Please show Mo some love. Do all the YouTubey things. And wherever we send you, please show them some love too, because we'll redirect you. And come back tomorrow. And thank you so much, Brandy, for the nice redirect. And I hope you will have a wonderful time in court, and we can maybe steal 2 seconds of your time now and again just to talk about what, if anything, Sarah smells like. Jamie has promised us that tomorrow she will show you how to build your own push-up bra with cheese slices.
Jail cheese.
Yes.
Jail cheese bras. Yep.
See you all in the morning. Bye.
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 What exhibit are you referring to?
I'm going to make this 100, Your Honor.
All right.
100.
100.
Because it is 100%
100%.
correct.
So you literally built a cannon?
Yeah, it's pretty awesome.
Hopefully tomorrow.
All right, I'm in love.
Go back. Please do that again. Oh, that was the cutest thing I've ever seen.
While I'm waiting for this, did you, whether it's true or not, believe that Mr. Randolph had slept with your wife?
I wouldn't have cared.
You wouldn't have cared?
No.
Did you believe he had slept with your wife?
No.
Did you believe he slept with your mother-in-law?
Probably did. Everybody has.